outside late, my lord. Second appeal number 221/2022, my lord. In this case, execution case.
Under the heading for orders bail number 30, kindly it may be heard at 4 o'clock. So urgent. Actually, it is the matter of eviction suit matter, and I have taken the consent from the other side also. Education suit.
So orders for what? This case have been listed.
ये orders नहीं है.
किस लिए? Defective है क्या?
नहीं. Yes. Education suit फाइल किए other respondents. Serial number 30.
पता ही नहीं.
We have
क्या agency है?
We have filed IL lawsuit for execution, for stay of the execution case, and also for there is a delay of lawsuit. So we have also filed for condonation of delay.
Condonation of delay.
There is delay of 18 days only lawsuit.
Other side has appeared.
Appeared also. We
Record आया है?
Yes, yesterday we have informed also.
Record आया है?
First delay करना होगा उसके बाद में भी. The second appeal has not been admitted also.
कहाँ है लोग?
Other
खबर
side
करने
time
other side.
Inform कर दिए. फोन से बोले कि मैं आ जाएंगे 4 बजे मैटर रहेगा करेंगे.
बुला.
from the list, orders item 1, second appeal 88 of 1984.
Yes.
Person 5 of subsection person was IA number 12986.
IA number
12986.
there are two IA. One is 13555 of 21. This is limitation.
Limitation.
Who has expired when? Who has expired
Full appellant was.
when? 2013.
Yes, sir.
Who is for the respondent? Who is for the respondent?
के प्रसाद was.
और कौन है इनके साथ? वकालत नामा. You have served copy on the other side.
No.
कॉपी नहीं सर्व किए तो कैसे आपका ये इसको सुनेंगे?
सर्व कर देते हैं. आज ही कर देते हैं.
SLAC क्या है ये? सुप्रीम कोर्ट कहती है.
Yes, sir.
क्या चीज़ है?
रेस्पोंडेंट नंबर 1 के अगेंस्ट में अवेट हुआ था, लेकिन पूरा केस को ये आपका डिस्पोज हो गया था.
Sorry? It's a good.
रेस्पोंडेंट नंबर 1 के अगेंस्ट में अवेट हो गया. फिर हो जाएगा पूरा प्रोसेस केस ही डिस्पोज हो गया. फिर लास्ट में फिर आपका रिस्टोरेशन फाइल किया उसमें. फिर रिस्टोरेशन में आपका लिमिटेशन ग्राउंड में डिसमिस हो गया. फिर जैसे ठीक है तो वहाँ बता कि नहीं हो सेकेंड अपील डिसमिस नहीं हुआ है, सिर्फ रेस्पोंडेंट नंबर 8 के अगेंस्ट में डिसमिस हुआ.
तो रेस्पोंडेंट नंबर 1 के अगेंस्ट में तो अबेटमेंट जो हुआ था वो तो रह गया ना, है ना? तो रेस्पोंडेंट नंबर 1 के अगेंस्ट में अगर अबेटमेंट रह गया तो आपके केस में कैसे डिग्री होगी? कैसे जजमेंट?
बाकी तो प्लांट है, अभी रेस्पोंडेंट है ना.
बाकी रिस्पॉन्डेंट डिग्री सेवरेबल है?
Yes.
कैसे? क्या चीज़ है? व्हाट इज द नेचर ऑफ सूट?
टाइटल सूट है.
टाइटल सूट ऑन द बेसिस ऑफ
सेल डीड और हथियार.
हु इज रेस्पॉन्ड नंबर 8? ही मस्ट बी द कंटेस्टिंग पार्टी. तभी आप गए भी थे सुप्रीम कोर्ट अबेटमेंट को लेकर. करेक्ट? राइट? हु इज रेस्पॉन्ड नंबर 8?
कंटेस्टेड नहीं हो, उसने परचेज किए तो कुछ जमीन उसी के पार्टी थे.
तो परचेजर अगर पार्टी है और उसके अगेंस्ट में आपका अपील डिसमिस हो गया है तो कैसे आपको रिलीफ मिल हाउ विल यू गेट द लीड?
बाकी रेस्पोंडेंट है
कैसे होगा? सेल लीड तो सेवरेबल नहीं है ना, बताइए हाउ विल इट प्रोसीड? बताइए उनका तो सेल लीड वैलिड हो गया क्योंकि अब उसको सेटिस्फाइड नहीं हो सकता क्योंकि उनके अगेंस्ट में वेट हो गया प्रोसीडिंग।
बाकी और सेंडिंग है
और भी सेल लीड है, कौन कौन सा सेल लीड बताइए जिसमें रेस्पोंडेंट नंबर 1 नहीं है वैसा सेल लीड। किस पॉइंट पे ये एडमिट हुआ था? What was the point? Substantial question of law involved? What is the substantial question of law? बताइए what is the substantial question of law? कुछ पता नहीं कौन है और कौन है इसमें रिस्पोंडेंट की तरफ से? एम शाह एम शाह तो बहुत पुरानी जाती है। महेश कुमार मेहतो ये कौन है? आप आयु आदित्य को बुलाइए, उन्हीं के चैम्बर में उनके प्रश्न। बाकी सर एडवोकेट्स कौन हैं? उनका नंबर वगैरह डिटेल है? उनका वकालतनामा कहाँ लगता है? वेयर इज द वकालतनामा? आपको कुछ नहीं पता सब्सटैंशियल क्वेश्चन ऑफ लॉ भी नहीं?
फाइल की मेमोरी नहीं, फाइल नहीं
बहुत ही अच्छी। तो क्यों ही लड़ रहे हैं?
मिल नहीं रहा, रिकॉर्ड में भी नहीं फाइल निकालने की कोशिश की तो मिला ही नहीं।
मिला नहीं मतलब गुम हो गया।
मेमो नहीं है, रिकॉर्ड में भी नहीं है,
क्या चीज़ रिकॉर्ड?
फाइल में, कोर्ट का फाइल में भी नहीं है मेमो।
आपके पास कॉपी नहीं है तो वकालतनामा फाइल किए, क्लाइंट आ रहा है, सब्स्टिट्यूशन फाइल कर रहे हैं, कहाँ है फाइल? लिटिगेंट हैज नॉट गिवन यू द फाइल, खाली वकालतनामा देके चले गए। रिकॉर्ड आ गया इसका, रिकॉर्ड तो आया हुआ है यहाँ।
मेमो नहीं है, मेमो
तो हम क्या करें, आपके घर जाके दे दें?
कोर्ट
क्या
का
करें?
कोर्ट का फाइल में भी नहीं है, वहाँ तो कोशिश की निकालने का तो नहीं है।
आप सुप्रीम कोर्ट गए थे ना, वहाँ मेमो अपील तो लगाए होंगे।
नहीं, वहाँ नहीं लगा।
कोई बात नहीं, सब्सटैंशियल क्वेश्चन ऑफ लॉ फ्रेम्ड है, मेमो ऑफ अपील का क्या काम है? कोई काम नहीं। सब्सटैंशियल क्वेश्चन ऑफ लॉ फ्रेम्ड है, क्या काम है मेमो ऑफ अपील? सेकेंड अपील में सब्सटैंशियल क्वेश्चन ऑफ लॉ जब ऑलरेडी फ्रेम्ड है तो मेमो ऑफ अपील का क्या काम? कोई काम नहीं है ना।
सब दे देते हैं आपको, अपोजिट पार्टी को रिसीव करवा लेते हैं, 2 सप्ताह का टाइम।
2 हफ्ता का टाइम चाहिए, इस बीच कोई और मर गया तो? सूट कब का है? सूट कब का है?
यहाँ पे 84 में आया है।
यहाँ 84 में आया है तो सूट तो आपके जन्म के पहले का होगा। नाइनटीन 1980 का है सूट। नाइनटीन और 1980। पार्टी पोजीशन इसमें मिलना बहुत मुश्किल है। एपलेट को डिग्री मिला है इसमें, उसी से पार्टी पोजीशन मिला। इसमें ऐसा करिए कि CLP नंबर जो है ना 337 और 2015 इसका रिकॉर्ड मंगाइए, इसमें सारा पार्टी पोजीशन। किसका डेथ हुआ है? अपीलांट।
यस सर।
अपीलांट का नाम क्या?
भक्तिमान।
हम्म?
भक्तिमान।
भक्ति में मोहन में,
ये तो उनका बेटा है।
ये तो अपील ही मोहन में तो फाइल की, सन ऑफ लेट भक्ति में।
और रेजोल्यूशन फाइल किए थे। सेकेंड अपील में भक्तिमान उनका बेटा के थे, आपको रेस्टोरेशन फाइल किए।
सेकेंड अपील हम लोग 88 of 1984 within bracket R. Respondent number 4 के अगेंस्ट में भी अवेट होगा. Yes. Abatement. 1A 1B इनका सब्स्टिट्यूशन हुआ था 1A 1B का. Who are 1A and 1B? Yes, who are 1A and 1B?
फिलहाल तो वन ही है.
भाई ऑर्डर शीट में लिखा हुआ है 1A 1B. मेमो कॉपी तो यहाँ है नहीं. आप उनको बुला के लेके आइए. मिस्टर आयुष आदित्य को बुला के लेके आइए. उनके चेम्बर में इसका मेमो होगा. तब इसको रिकॉन्स्टिट्यूट करना पड़ेगा. ठीक है, 2:15 बजे तक. कोर्ट का रिकॉर्ड में नहीं है. हाँ, अभी आ ही रहे. थोड़ा देर 10 मिनट के बाद आ. उनको बताइए तब तक क्या प्रॉब्लम है.
Article 2, second bill 58 of 1991, along with Article 3.
चलो आगे प्लीज. स्टार्ट. एक ही साथ notice बनानी है. Yes, what is the office note? Yes, Apilan, I am asking you. What is the office note?
नेक्स्ट की रख लिया जाए मैडम. ट्रेन यहाँ नहीं है. ट्रेन लेट है उनका. सीरियल नंबर 2 और 3.
इसमें ऑर्डिनरी प्रोसेस का सर्विस रिपोर्ट ड्रॉपशिप आया नहीं है और स्पीड पोस्ट का सर्विस रिपोर्ट में आया है तो सफिशिएंट एड्रेस नहीं है.
ऑर्डनरी प्रोसेस का वेटिंग कर रहे हैं.
हाँ वेटिंग.
SA 58 of 1991 with SA 1991 within bracket R with SA number 69 of 1991 within bracket R. Counsel for the parties are present.
नोटिस हुआ था सेकंड अप्रैल 58 ऑफ 1991 में लॉर्ड.
post this case on third of November 25, awaiting service report of the ordinary process of notice issued under
Ordinary
ordinary
process.
office to send reminder for the service.
Item 4, second appeal 522 of 1991.
Appellant. Yes, appellant. You were supposed to file wakalatnama on behalf of deceased respondent number. Substituted legal years of respondent number 1.
Yes, I have received some of the wakalatnama. I will verify and I will.
Some of them.
Yes, I have received the wakalatnama. Melody is with me now.
वेरीफाई करके बताइए किसका किसका.
Yes, that is.
अब वेरीफाई करके बताइए.
Yes, it's just now. I have
पुराना
received.
केस पे इस तरह से जर्नी
नहीं नहीं.
दे दीजिए को रिकॉर्ड.
Yes.
स्पेलिंग चेक कर लीजिएगा नहीं तो वकालतनामा में डिफेक्ट कर जाएगा.
दस्तखत जो कि वही. अब वो नाम क्या लिखे दस्तखत.
जो भी दस्तखत कैसा भी हो लेकिन नाम आपका सही रहना चाहिए.
हाँ हाँ. Yes, yes.
Madam, your senior has not come today. Your senior has not come to the court.
He is not well.
He is not well. वो कहाँ है इनकी आईडी?
Daily to
ये जो है ना एक मिस्टर पी के प्रसाद का वकालतनामा है, राइट? तो रिकॉर्ड इनके ऑफिस में होगा.
let's see that is not our case.
I know.
Item 1
Some,
में जो केस
whose
है
case is that? Whose case is that? Yes. Do you have any idea whose case is that? आप क्या उसमें?
I for the respondents note in this case.
Which case?
Seal number 5.
5 minutes.
अभी 1 में इसके बाद 5.
Do you have any idea?
No. I'll ask.
Ask your senior because there are 2 other persons whose wakalatnama is there. We do not know who are they.
Okay.
Okay? We are posting it tomorrow. Okay? इसको कल कीजिए. हाँ, उनको भी और बाकी लोग भी जो है ना वकालतनामा लिखा है कुछ भी. अब कल आई. अकेला कल आई. कॉपी? वो बोलते हैं उनका केस ही नहीं है तो किनको कॉपी दे दीजिए. कल आइए नहीं तो नोटिस करेंगे. कम से कम पार्टी पोजीशन तो पता करिए. एसएलपी में तो पूरा पार्टी पोजीशन फाइल हुआ होगा ना. एसएलपी तो रिसेंट है ना, उसमें तो पार्टी पोजीशन होगा सारा. आप लोग इस तरह से खड़े हो जाइएगा तो क्या मतलब है इसमें? आपको एसएलपी का कॉपी भी नहीं मिल सकता है आपको. किसका मेमो नहीं मिला? वो नहीं है इसीलिए तो डिसमिस कर दे इसी ग्राउंड में कि मेमो नहीं है आपके पास. न कोर्ट के पास भी मेमो नहीं है. कोर्ट के पास भी मेमो नहीं है उसका. सब्सटेंशियल क्वेश्चन ऑफ लॉ हैज ऑलरेडी बीन फ्रेम्ड. तो कहानी खत्म. हमें तो नहीं चाहिए मेमो. पार्टी पोजीशन के लिए हमें मेमो चाहिए. तो एसएलपी में जो फाइल हुआ होगा उसमें पार्टी पोजीशन होगा ना. नहीं समझ आ रही बात? फिर उसी से रिकॉन्स्टिट्यूट करेंगे मेमो में कम से कम पार्टी पोजीशन ऑफ द सेकंड अपील. डिस्पोजल करना है कि ऐसे ही छोड़ देते हैं बाकी सब लोग भी मर जाएंगे उसके बाद फिर कोई कैप्चर कर लेगा आपका प्रॉपर्टी. बस चलते रहेगा. बताइए. नहीं समझ आ रही बात? नहीं कर ही रखना. एसएलपी का कॉपी लिखिए. सॉफ्ट कॉपी मंगाइए अपने वकील साहब से. सॉफ्ट कॉपी मंगाइए वकील साहब से, इनको फॉरवर्ड करें, ठीक है?
Item 5, second appeal 14 of 1995.
Make visual. But notices were issued. We have order dated 1/9/2025. In respect of IN number 10834 of 2025. Particularly is today we find that on 25th of September there is a office note service including service report whereby postal clean report in respect of 1C1 and 1C2 is addressee left, so it is undelivered. Time may be given, I will seek information about the whereabouts if we can get.
Essay 14 of 1995 in the Quran. Counsel for the appellant submits that as per office note, the notice issued to respondent number 1C within bracket 1 and 1C within bracket 2 has been returned with postal peon's note within bracket addressee left. How much time do you need?
I will seek
The learned counsel for the appellant prays for and is allowed 2 weeks time to take appropriate steps at the present and correct address of the aforesaid proposed legal hearsay,
Yes,
proposed legal heirs and successors of respondent number 1 within bracket C
aforesaid to
for and the requisites be filed under speed post at present and correct address or to take appropriate steps in connection with service of notice. That is substitute. Nahi mile to you have to tell us that you have not been able to find out their address and then go for substituted service. 2 पेपर में पब्लिकेशन कराएंगे और केस
Right.
डिसाइड करेंगे. Close this case on 10th November.
oblige.
Item 6, second appeal 132 of 1998.
Appellant
One petition for substitution was filed. I am for respondent.
who is for the appellant. Notice has not been issued on the point of substitution. Notice has been issued or not issued?
Notice was issued,
What is the report?
but the death is of 2011 and substitution filed in 25 now. Abated also. After 90 days, when not substituted, not then abates. So they have to file also for setting aside the
They
abatement.
are not filing any petition for setting aside the abatement.
Not
No
filed.
such petition has been
Only
filed.
substitution petition.
Notice has been served. 11213.
Yeah.
Where is the ID? In paragraph 4, we say that the petitioner was not aware about the death of the respondent number 1. As such, this application is being made to set aside the application.
It's a tenant, landlord and tenant relationship.
Appellant is the tenant.
No, appellants not are the landlord. And respondents are the tenants.
You see, although no specific prayer has been made, but they have said that they were not aware about the death of respondent.
As you lost.
Now the service is complete. Who is now appearing for respondent number? You are appearing for respondent number 1.
I was appearing for both of them,
Okay.
but now one has died.
Now 1 has died. So 1 and 1, 3 will you be representing because no fresh wakalatnama as such has been filed.
Wakalatnama I will not present.
Yes. The notice has been served upon them.
On the substituted
Yes,
AS.
1, 1, 2, 1, 3. It has been delivered. We will proceed. If they do not appear, we will just record that notice has been served. You are for 1, 2 also. For respondent number 2 also you are appearing.
No,
Respondent number 2 is also the tenant.
both tenants.
Both are tenants. देखिए ऐसे नंबर 132 of 1998 Appellant का advocate कौन है? सुनील कुमार जी. Where is the counsel? यही है झारखंड हाईकोर्ट का स्थिति. फिर बोलेंगे केस टिकट नहीं. 98 का चल रहा है सेकेंड. अलाउ कर देते हैं सब. अगर डिसमिस कर देंगे नॉन अपीयरेंस पर. सेकेंड अपील डिसमिस. यही कर सकते हैं. क्या करें? या अमेरिका से अपॉइंट करें. These are two things we can do about it. IE number 11057 of 2025. In SA number 132 of 1998 Democratic Field.
Where is the cause list?
Sorry.
The lawyers for the appellant are Miss Mallika Mazumdar, Rajiv Ranjan, Sunil Kumar Gule.
They are not. Nobody appears on behalf of the applicant. The learned counsel for the respondent number 2 is present. You are respondent number 2?
No.
Is present. this petition has been filed for substitution of respondent number 1 and for setting aside abatement. As per the amendments made in the petition, the respondent number 1 had expired on 4/5/2011. The names of legal heirs and successors have been mentioned in paragraph 2 of the utility application. Notice was issued to the proposed legal heirs and successors, and as per office note, the notice has been delivered on 16/9/2025, but nobody has entered a grievance on it. In the utility application, it has been mentioned that the petitioner was not aware about the death of respondent number 1. And as such, petition has also been filed for setting aside abatement and substitution. The learned counsel representing respondent number 2 has submitted that the matter relates to landlord-tenant relationship and the respondents are the tenants on the property. No counter affidavit as such has been filed to the utility application seeking substitution. After hearing the learned counsel for the respondent, and considering the amendments made in the utility application, IE number 11057 of 2025 is hereby allowed. The office is directed to delete the name of respondent number 1 from the clause title and insert the name of legal heirs and successors, whose details has been mentioned in paragraph 2 of the utility. ये तो हुआ आइए था. Now सेकेंड अपील सुनवाई के लिए क्या हमको फिर से नोटिस करने का पर्पस नहीं. Substitution has been allowed. Now is there any requirement of any fresh notice today?
सब्स्टिट्यूशन पर ऊपर गया था तो इस पर तो जाएगा ही. सेकंड अपील.
तो सेकेंड अपील पे क्या फिर से नोटिस जाएगा? कोई मतलब नहीं. Is there any requirement of fresh notice? Why have you come?
Serial number 6 में
So what is the matter?
वो लास्ट टाइम में सब्स्टिट्यूशन पिटीशन पर नोटिस हुआ था. नोटिस होता है.
आप नहीं आए थे सब्स्टिट्यूशन अलाउ कर दिया. आपका अपीयरेंस हम इससे रिकॉर्ड नहीं कर सकते.
खांसी हो रहा था रास्ते में.
इनका अपीयरेंस. अब क्या करना है? उनको सेकेंड अपील में फिर से नोटिस करने का तो रिक्वायरमेंट दोबारा तो नहीं जाएगा नोटिस. अब बहस करना शुरू हो गया. सब्स्टिट्यूशन स्टार्ट आर्गुमेंट.
मैडम क्विक नेक्स्ट डेट दे दीजिए.
कल दे सकते हैं क्योंकि आप
Next-
फास्ट हैं.
नेक्स्ट
नेक्स्ट मतलब इसीलिए
फीवर भी बहुत हुआ ना मैं स्पेशल इसी के लिए आया नहीं तो आज नहीं. अच्छा वकालत नंबर
रिकॉर्ड दे सर. आप जरा पढ़िए तो जजमेंट क्या मैटर है. आप बैठ जाइए. आपको फीवर आ बैठ जाइए.
Matter is very simple, my lord. Default for non-payment of rent.
That is only ground.
That is only the ground. And on the plea that it was month-to-month tenant, which was decreed by the trial court, reversed by the appellate court,
Saying what?
saying that admittedly, according to the evidence also, it was found that no months to months tenant agreement was there. No agreement was there. It was found that since 1962, the title suit was filed in 84. Since 62, the relationship of landlord and tenant is going on, and prior to us, our partners, they were the tenant, and when we became partner, we also started accepting them as landlord and started paying. So no agreement,
Maybe.
month to month agreement
Need
payment
not be
was
there.
there, number one. And secondly, it was found by the court below that the payments for months together were at one time paid and the receipts were granted. Those receipts have also been exhibited. So this is
en-bloc payment was there.
en bloc payment,
Prior
for
to
which
suit or after
receipts are there, exhibits are there.
Prior to suit or after suit?
No, prior to suit. Prior to suit,
What is the substantial question of law framed?
substantial question of law है substantial question of law है.
What is the substantial question of law? Yes, counsel. Appellant. ऐसा है, इसको कल रखते हैं. केस देख के बुखार मत चढ़ाया करिए.
नहीं हम ऑलरेडी कल से क्लियर.
नेक्स्ट वीक से तो फिर छुट्टी का टाइम आ जाएगा. परसों रखो. यू जस्ट कम प्रिपेयर योरसेल्फ. छोटा सा मैटर है.
Thursday.
इतना आपका जो है ना सब्स्टिट्यूशन पिटीशन हमको डिस्मिस कर देना चाहिए. कितना डिले है आपका? वो नहीं दिख रहा आपको. परसों आइए, थोड़ा आराम से पढ़ लीजिए. सब्सटेंशियल क्वेश्चन ऑफ लॉ 22/4/99 को बना है. यू जस्ट हैव अ लुक एट इट. कुछ लैंडलॉर्ड टेनेंट रिलेशनशिप में ज़्यादा नहीं है. ऐसा नहीं है कि आप नोट नहीं आ रहे हैं. वी आर नॉट गेटिंग. यू टेक टाइम एंड ब्रीफ है आपके पास. ब्रीफ भी नहीं है ना. सर्टिफाइड. ये दो सब्सटेंशियल क्वेश्चन ऑफ लॉ बना है. इसी पर आदमी बेसिक इन्होंने एन ब्लॉक स्टूडेंट पेमेंट किया है, राइट. तो उसका क्या कॉन्सिक्वेंसेस होगा, और जजमेंट भी इसमें सब्सटेंशियल क्वेश्चन ऑफ लॉ भी है, राइट.
वैसे नीचे कोर्ट में भी वो इनहांस के लिए हम लोग डिमांड किए कि वो रेंट जो है 1962 या 84 जो मिल रहा है वही अभी तक.
देखिए, जो सब्सटेंशियल क्वेश्चन ऑफ लॉ बना है उतना पढ़ सुनिए ना, उसके बियॉन्ड नहीं सुनिए. उसको परसों रखते हैं, दोनों जजमेंट्स को पढ़ लीजिए, ठीक है. आपका इतना डिलेड सब्स्टिट्यूशन हम अलाउ कर दिए, जो हम डिस्कस करते थे 1 मिनट में डिस्कस हो गया, है ना. आप इसको पढ़ लीजिए, आप कुछ करने को नहीं.
substantial question of law
The matter is directed to be posted. आज मंडे है, थर्सडे को रख देते हैं, ठीक है. Is directed to be posted on Thursday to be taken up as the first case at 10:30. ठीक है, for hearing on minutes. आप किन की तरफ से हैं? आप किन की तरफ से हैं? आप
मेरे साथ जैसा वो
हाँ दिखाइए, उनको भी
Item
आप
7.
देख लीजिए सब्सटेंशियल क्वेश्चन, आप लोग बहस करना।
Item 7. Second appeal 126 of 2003.
Therefore, you are to stand to file
File what?
substitution petition.
किसका डेथ हुआ है कब?
Respondent number 1 का डेथ हुआ
बात कब हुआ है डेथ?
लास्ट ओकेजन
I have supplied the details of the bloody is not. ले ले अब फाइल करें, हमारे पास वकालतनामा भी आ गया लीगल हेयर्स का. He should file
कब
it.
डेथ हुआ?
2022. I have received the वकालतनामा also of all the legal heirs.
क्या करते हैं?
Unless
टाइम लेने के लिए तो है आप लोग का काम ही है टाइम लेना। नहीं मत बोलिए, यही मेरा एक्सपीरियंस है। फिर बोलिएगा कोर्ट में केस टेकअप नहीं, यही है बाहर जाके ही बोलिएगा केस टेकअप नहीं होगा। यही है, यही कहानी है झारखंड में, तो यही कहानी टाइम लेने में सब एक्सपर्ट। पिछली बार भी इसीलिए टाइम हुआ।
डिटेल नहीं मिल पाया थी,
डिटेल आप कब दिए इनको डिटेल?
अभी तो उस दिन भी बोले कि ले लीजिए, मेरे पास डिटेल्स है. I am ready to provide him the details. I have received the वकालतनामा on last occasion also. I have informed him this.
1 वीक का टाइम मुझे दे दिया।
अभी बैठ के पहले डिटेल लिखे, तब आपको पहले डिटेल ले लीजिए, उसके बाद 1 वीक का टाइम दीजिए। पहले डिटेल ले लीजिए, उसके बाद आपका सबमिशन लिखाएंगे कि आपको सारा डिटेल मिल गया है, तब तक ऐसे नहीं दे।
लिख लो
अभी लिख के पास ओवर है, लिख के बताइए।
Milord, in serial number 4, I have examined, Milord. Milord, so far 1A1, Milord, she has died. Her legal heirs are already on record, Milord. I have already appeared. And 1C to 1H, Milord, my appearance has been accepted by it order date 10/1.
अच्छा कॉल होगा तब ये वाला कौन सा?
सीरियल नंबर 4 जो है ये हो गया था वो.
आप इसका पहले
इनको दे देते हैं, तुरंत दे देते हैं. ये वाला जो
आपके जूनियर है?
हाँ, यस.
आप नोट करिए सारे, स्पेलिंग के साथ नोट करिए
जी.
बहुत परेशान ऐसे नहीं आपको जाने देंगे, आज आपसे काम करवा के भेजेंगे।
Password case here, item 4, second appeal part 2 of 1991.
हाँ बताइए, इसमें क्या बोल रहे हैं?
1A1 Draupadi Devya. She had died. They have not filed any application for substitution. But although the legal heirs, her sons are on record, I have appeared. So far 1C to 1H, my appearance has validly been accepted on white order dated 10/1/2018. Your Lordship में 10/1/2008 order में kindly be seen. सबका appearance हो गया है इसमें. They are not appearing before this court. एक अपील ऑलरेडी अबेट करके डिसमिस हो गया है और एक अपील का ये पोजीशन है.
सुनील कुमार नहीं।
Yes. वही है.
रिक्वेस्ट पे नहीं फाइल।
रिक्विजिट है उसका, हम अपियर कर गए हैं और लीगल हेयर से उसका जरूरत ही नहीं है. सी हैड डाइड.
कौन है रेस्पोंडेंट नंबर 2 हैज डाइड?
1A1.
1
A small 1 Roman 1 Draupadi Devya, and her legal heirs are 1A1 2 3 4. No office note में kindly with regard to Draupadi Devya there is bold black. Only her name is to be deleted by them.
पहले पुराना वाला ऑफिस नोट।
नहीं, ये नया वाला में.
ये नया वाला records of earlier time now awaiting. तो अवेट कर दिया, पूरा ही अवेट कर दिया।
हाँ, उनका अपील है.
No requisite of notice upon legal years of deceased respondent number 2 has been filed.
They have not filed.
They have not filed. As such, due to non-compliance of order dated.
It was dismissed for default, but sir, thereafter it has been restored because they have filed the appearance in the substitution petition in the next appeal, 521.
So that has been
Yes, yes.
Wakalatnama on behalf of respondent number 1A1 has not been filed.
Filed. Draupadi, she had died. Therefore, her legal heirs, the sons are already on
From
record.
where do I get that she has died?
But this fact was informed to them long back. but they are not taking
I
any
don't
action.
have anything on record.
That is.
आप ही affidavit में file कर दीजिए that the legal years are already on record.
It will be apparent, my lord, because 1A has come in place of 1A, my lord, that Raghunath Chaudhary.
नहीं 1A 1 Draupadi Divya
हाँ,
has
she is legal
expired.
heirs of 1A.
1A.
Yeah, 1A.
That Draupadi Divya has
Is
expired.
with-
From
yeah.
where do I get this? इसका तो affidavit होना चाहिए ना record पर.
This was informed, they have taken time and yes,
आप-
I will give
आप
one
एक-
line.
एक-
Yes, yes,
एक ID
intimation
file कर दीजिए that
Yes.
her name may be deleted, the legal years are already on record.
on record. That they are
बस
already.
पूरा होने से we will proceed.
Yes, yes, on record.
ठीक है.
Legal heirs are already 1A, 2, 3, 4.
हाँ.
That through.
और ये जो notice upon legal years of deceased respond number 2, which was earlier dismissed and then it was restored.
Yes, that restored, that will be from the connecting file. In that they have substituted. Therefore, the court has said that since there is substitution already in the record, therefore this honorable court has
वो
said.
कहाँ है? वो CMP का order था.
वो एक और अपील है 521 जो अवेट कर गया है, जिसमें they have filed.
एक CMP तो होना चाहिए ना.
हाँ,
Where is
in
that?
521 they have.
521 में क्या है इसमें?
इसमें already they have filed substitution and that.
If they have filed substitution, there has to be an order in this record of restoration. There is nothing mentioned that it has been restored. इसमें इस order
इसमें दोनों का jointly चल रहा था, इसलिए एक ही में ऑर्डर चल रहा था, इसी के लिए.
ये 25 में ऑर्डर हुआ था 8/8/25 जो डिसमिस हो गया. उसके बाद 25 के बाद का रेस्टोरेशन होना चाहिए ना.
नहीं लोग कोई फाइल किए, ये लोग ये
नहीं फाइल किया है तो डिसमिस हो गया, बात खत्म है.
ठीक
तो
है.
इससे क्या लेना देना?
And neither they are appearing.
आप उसका फाइल कर दीजिए, उसके बाद we will see now it is dismissed.
Today, Milord, today I will file, Milord, because one of the legal heirs is present in the court.
Yes, you file.
Today I will
Then
file.
we will record that it has already been dismissed against such and such, and
Yes.
then proceed and decide
Yes,
if
yes.
dismiss कर देंगे.
Yes, yes.
If they are not interested.
Yes.
You see, unless दो बड़ा hurdle है,
Yeah.
दो बड़ा, unless the limitation is taken care of, and unless the party position and substitution is taken care of,
Milord.
second appeal हम merit पे भी नहीं dismiss कर
Yes.
पाएंगे.
Let it be day after tomorrow or Thursday, Milord.
Order करते हैं
Yes, yes. Because the legal heirs is here, I can affidavit and
Yes.
file it. Yes. That will be because they are not taking.
हाँ,
Milord, I am
आइए के रूप में फाइल करें.
IA के रूप में file करें.
Essay number 522 of 1991 within bracket P. Nobody appears on behalf of the applicant. As per the office note, since requisites of notice upon legal years of deceased respondent number 2 has not been filed, in terms of order dated 8/8/25, the case has stood dismissed as against the legal years of deceased respondent number 2, that is against respondent number 2, 1 and 2, 3. The learned counsel for the respondent has submitted that Draupadi Divya has already expired, who was respondent number 1A with bracket 1, and he has already received wakalatnama on behalf of.
No, wakalatnama is already filed on
Yes,
behalf of her.
the wakalatnama on behalf of the remaining legal years of 1A has already been filed, and therefore her legal years are on record. He submits that an appropriate petition will be filed by tomorrow,
Yes.
and let the matter be proceeded
Thursday.
on Thursday. Let this, in view of the submissions, close this matter.
On Thursday.
Yeah.
Day after tomorrow.
Late Thursday.
Thursday.
Serial 7 I have taken.
हो गया?
Yes.
लाइए सीरियल 7 का.
I take leave, Milord.
हाँ sure. The learned counsel for the parties are present.
Item 7.
The learned counsel for the appellant has submitted that he has received the details of legal heirs and successors of respondent number 1 from the counsel of the respondent. He prays that the matter be posted in the next week.
2 weeks call करना होगा.
He prays that the matter be listed after 2 weeks. Post on 29th of October. 29 नहीं, 30 तारीख. एक दिन बीच में गैप है.
जी.
Setting aside abatement वगैरह सब फाइल करते हैं.
सब.
Limitation, setting aside abatement, substitution, all the things. एक ही नहीं रहेगा तो नहीं.
जी 3 petition.
Sorry.
3 आई है.
एक ही में हो जाता है. वो तो एक ही में चलता है. लेकिन प्रेयर तो सही हो. उनसे पूछिए. अपना उनसे पूछिए कैसे बनता है.
जी.
For hearing item 8, 7 Bill 170 of 2002.
Last occasion, Lordship, time was granted for filing substitution petition. Today I am filing, Lordship.
You are filing it today.
Today I will file, Lordship.
Who has expired?
Sole respondent, Lordship.
Are you for this? Have you received Bakalat?
Lordship, notice to be issued.
Notice will go. Oh, why are you here? You have not received instructions.
We had received, Your Lordship, so far the original respondent was there. She died, he died. Your Lordship. Subsequently, her legal heirs instruction, we had to just receive that instruction. Although the legal details of the legal heirs have been given
Who
back.
has expired? Respondent number 1A.
Sole respondent.
Sole respondent.
Sole respondent.
Supriya Majumdar, Your Lordship. And although the instruction I have that the appeal which has been referred before the Deputy Commissioner, that has been dismissed, but Your Lordship has asked for the
Yes.
yes.
Report has come.
I haven't gone through that. Okay. How many? मैं तो कुछ कंसर्न नहीं हूँ. But मुझे
1100 रुपया प्रतिमाह निर्धारित किया जाता है. ये तो ओरिजिनल का होगा. HRC अपील.
HRC before the Deputy Commissioner.
before the
Deputy Commissioner. Yes. So that was decided.
that was
1100 per month.
11.
इसको कल रखना है फाइल के लिए.
जी.
आप पे एक और केस होना है. You were not appealing. Second appeal number 170 of 2002. Counsel for the appellant submits that he shall file appropriate petition for substitution of respondent number 1 during the
Sole respondent.
The sole respondent during the course of the day, post tomorrow. इसका आपको यहाँ से परमिशन लेना पड़ेगा, है ना? और उसको साथ में लगा देंगे.
And tomorrow I'll receive the instruction.
Yes, if you
Whether
receive the
we
instructions,
then we'll file the bakalat.
You file the landlord tenant.
Landlord.
आप कौन है? Landlord and tenant.
हम landlord हैं.
आप landlord हैं.
हम
आपको ज़्यादा जल्दी होना चाहिए.
जल्दी होना चाहिए.
Lordship, report has been come from the Deputy Commissioner, Lordship.
हाँ, 1100.
May I take the copy of the photocopy, Lordship?
फोटोकॉपी हम नहीं दे सकते. आप ऐसे पढ़ सकते हैं.
ठीक है, हम
Your Lordship, 170, I think no objection has been taken by it. I'll just, because that is not there in my list.
The financial item 9, second bill 293 of
Oh, 170 तो यही वाला है, Your Lordship.
178 is
हाँ.
Somebody has taken no objection.
नहीं, ये तो यही था. नहीं, Your Lordship said ना कि there was one more case.
matter. I saw आपकी जूनियर का क्या नाम है?
आरती साहब
वो स्वीट सी जूनियर आपकी क्या नाम है इसका?
निहारिका.
निहारिका.
ओ निहारिका का.
इसको वकालत
वकालत नाम से ऐसा तब मिला सब.
हमको लगा कि शायद उन्हीं का
नहीं हाँ निहारिका का होगा तो मेरे को I'll just go through the list.
चलिए. Yes, who is there in this case?
Item 9.
There's an IA per minus for additional substantial portion of
Yes.
On the last occasion also, a copy of IA was to be served, which is not yet been served.
copy has been served, madam. Your lordship may kindly see. And apart from that, madam, last 3 or 4 occasions, one pretext or other, they are seeking adjournment. Every date, one day before, I get a screenshot of an email sent to the court.
Amit Kumar.
Yes, his name is there.
Pratyush Chanakya.
Amit Kumar Sinha has received the copy.
I have instructions that the copy has not been served. But, the argument counsel is not here. He has already sent an email to the court. Yes.
Sending email is not your right. Just sending email is your right, but adjournment is not. You argue on substantial. बताइए. What is the additional substantial? Madam, you be prepared. We do not.
Leadership, I am not aware of.
He could have just asked him. I would have
You are
given
not
a
aware.
copy.
Why are you standing?
On behalf of the argument counsel, he has.
Amit Kumar Sinha. Who is Amit Kumar Sinha?
Pratyush Chanakya has to argue the case.
Who's वकालतनामा है Amit Kumar Sinha?
Amit Sinha is
not an advocate on record. Who is not an advocate?
His name is there.
Amit Sinha is not an.
I checked the record also, his name is there.
This is serial number?
Serial number 9.
Amit Kumar Sinha is not.
His name is there?
Amit Sinha.
Yes. Amit Sinha. His name is very much there.
Leadership Amit Sinha or Amit Kumar Sinha.
Tally कर लेते हैं, चिंता मत करिए. I am there to assist you. You are not capable of. उनका वकालतनामा का निकालिए जरा. उनका वकालतनामा निकालिए. Respondent. Just check.
Additional substantial question of law is at paragraph number 10.
What is that?
When it's suit was ultimately discussed, this if there's 2 months default under the Rent Control Act, eviction is maintainable. The learned court has come to the finding that 4 months default is necessary as per the agreement.
4 months.
As per the agreement.
As per the.
So the substantial question of law is whether.
You see, Amit Sinha, enrollment number 357 of 2007, and tally करके इनको बताना पड़ेगा. Enrollment number 541 of 2007. आपके किसी और Amit Sinha and Amit Kumar Sinha are 2 persons.
That's how the copy contains. He could have just asked. Since last 3-4 days, he's just sending an email. And this is on the ground of ID. Otherwise, also he's been sending emails and he just sends me a screenshot.
Leadership, it may be kept
Could have just
for tomorrow,
informed.
leadership. The copy may be served.
अभी इनको दे दो.
Yes.
Right now. Madam, he is here in the court. Civil practitioner है. आप आइए यहाँ से लेके जाइए. I will record that you have been served. Should I?
Yes.
Essay number 293 of 2017. The counsel for the parties are present. It seems that the copy of interlocutory application has been served on a counsel who is not the advocate on record on behalf of the respondents. The counsel for the applicant has served a copy of the interrogatory application to the counsel appearing on behalf of the respondents, and at the request of the respondents, posts his case to the court. On the point of payment, additional substantial question. Record आ गया ना इसका? You see, you get ready because once we frame additional substantial question of law, we substantially hear the matter, right? We'll frame it and post it. Just we'll give you 1 day and then we'll decide. You also get ready.
Yes. That case is not our case. That is Malaika Mazumdar. She was the junior. I think now she has left. She is some Mr. Dume. Some Mr. Dume.
Item 10, second bit 542 of 2018.
Yes.
I'm paying for the appellate. I'm paying for not today.
Not today. Why not today?
Let's say I have not been able to go through the file properly.
They have not been able to do. You have to agitate this?
Yes.
You have to agitate this, no?
Me, my seniors.
Who is your senior?
Sanjay Martiwari.
Call him. You will have your chance tomorrow only. You have not read it at home, we will read it now. चलिए substantial question of law क्या है? बुलाइए उनको.
The substantial question of law it was framed on 21/7/25. Lordship may see for paragraph 3 after hearing the counsel for the appellant, the second appeal is admitted for final hearing on the following substantial question of law, Lordship. Whether the learned first appellate court was justified in holding that the registered gift deed number 2285 dated 10/6/99 in favor of defendant number 1 was forced and void ab initio. And prior to that, paragraph 2 may be seen, Lordship. The learned counsel submit that there is no defective finding recorded by both the courts with regard to the date of death of Jagannath Mahto. However, the gift deed has been disbelieved. He has submitted that the courts have not considered the presumption in connection with the execution of registered document, and therefore substantial question of law be framed in this case. The facts of the case is Lordship, just I am explaining. There was one Rameswar Mata, Lordship. The genealogical table has been mentioned in.
नहीं ऐसे नहीं सकेना पहले case of respective parties पढ़ें. Case of respective parties. Right quotes. What was the prayer? The case was challenging this particular gift deed only.
Yes, Lordship.
It was specifically challenged.
The prayer in the plain was, Lordship, that the petitioner the plaintiff has got right title interest over the land which has been left out by Jagannath Mahto, who has died, and thereafter the deed of gift was executed on 10/6/99 is a void deed and it has been manipulated and manufactured by the defendant number 1. That was the main prayer made in the plain, Lordship. Lordship may see the trial court judgment.
And you read the first paragraph.
Page
ये
18.
तीन paragraph आपका.
Page 18, Lordship. Of the brief, the title suit has been filed by Ugan Mahto, plaintiff, against Srimati Urmila Devi, another defendant, for declaration of right title of plaintiff, appertaining to suit property as described in C2A and C2B, the property being of khata number 1, plot number 64/81, area 0.86 acres, including standing trees and property of khata number 1, plot number 11/262, area 2.92 acres, and property of khata number 1, plot number 12/261, area 2.40 acres, and property of khata number 1.
Next paragraph.
Yes, Lordship. Thereafter, the brief facts, total altogether area of the land 4.02 acres. Para to the brief facts of the petition case is that one Jagannath Mahto plaintiff, one of the uncle, continued in possession of land along with house and trees standing thereon till his death, as mentioned in Schedule of the plain appended foot of it with his suit land. The genealogy of the parties are given below. page 19, Lordship.
Where is Jagannath Mahto?
Jagannath Mahto,
Yes,
Lordship, may see
died.
that
Died on
Kaleshwar
4,
Mahto,
5.
Lalu Mahto had 3 sons. Lochan, Paltu and Jagannath. Lochan and Paltu died issueless during their adulthood before marriage, and Jagannath Mahto, he is the main contesting party, Lordship. Thereafter, Hari Mahto had 2 sons.
Jagannath Mahto died on 4/5/99.
They say 4/5/99, but our case is he has died on 4/8/99.
4/8/99.
4/8/99.
You read further. We have seen this one.
Hari Mahto had 2 sons, Sukan Mahto and Ugan Mahto. Ugan Mahto is the plaintiff, he has filed the suit, and Sukan Mahto has 4 daughters and 1 son. Wife is Padmanya Devi, then Jitni, Malti, Santi and Urmila.
And who is the defendant?
Defendant Urmila Devi is the defendant number 1.
Plaintiff is Sukan Mahto.
Plaintiff is Ugan Mahto.
Ugan Mahto.
Ugan Mahto. Plaintiff is Ugan Mahto.
Plaintiff.
And defendant number
And
1.
Sukan Mahto is who? Sukan Mahto.
Sukan Mahto.
He also died.
He has died.
Urmila Devi is the
In 1990.
defendant.
Urmila Devi is the daughter of the Sukan Mahto.
That is the defendant.
Defendant number 1.
Defendant number 1.
And defendant number 2 is Bansi Mahto, who is husband of the Urmila Devi.
Urmila Devi's husband.
Yes, Lord. Defendant number 2, Bansi Mahto, is the husband of defendant number 1, Urmila Devi. Your master table is clear now?
Just this one. The Learned Council for Jharkhand has referred to the order dated 21/7/2025, wherein the substantial question of law has been claimed as angered. With respect to the party position, the Learned Council has referred to the Trial Court Judgment Act, internal page 2, and has submitted that the plaintiff, that the common ancestor was
Kaleshwar Mahto.
Kaleshwar Mahto, who had 2 sons, Lalu Mahto and Jhari Mahto.
Yes, ma'am.
Jhari Mahto had 2 sons, Sukan Mahto and Ugan Mahto.
Yes, ma'am.
Sukan Mahto died in 1991, and the plaintiff is Ugan Mahto.
Google.
The defendants are, there are 2 defendants.
Defendant है जाते हैं.
अच्छा,
1 and 2 है.
Just-
Urmila Devi है ये.
Defendant number 1 is Urmila Devi,
Yes, Lord.
who is daughter of Sukan Mahto, and defendant number 2 is Bansi Mahto,
Bansi Mahto.
who is wife of, who is
Bansi
husband
Yadav,
of
Yadav लिखते हैं.
Bansi Yadav, Bansi Yadav, who is husband of defendant number 1.
Paul, yes, ma'am. And Lordship may say Lalu Mahto का जो है, he has 3 sons, Lochan, Paltu and Jagannath.
The Learned Council has further submitted that, as per the genealogical table, Lalu Mahto had 3 sons, Lochan, Paltu and Jagannath, and Lochan and Paltu had died issueless, and Jagannath Mahto, as per the plaint, died on 4/5/1999.
But our
He
assumption is,
submits that the appellant is the defendant,
yes, Lordship.
and as per the specific case of the defendant, Jagannath Mahto had expired on
4/8/99.
4/8/99,
Yes.
which is okay, 4/8/99 and not on 4/5/99.
Yes, yes.
And the entire answer to the substantial question of law is dependent upon the date of death of Jagannath.
Yes, sir.
But yeah,
It is said that both the brothers Lalu and Jhari Mahto made separation from each other after survey settlement operation and continued in cultivating position over their separate lands till their death, and thereafter their sons succeeded.
ये तो सारा वही कहानी है.
हाँ वही कहानी है. उसके बाद Lalu Mahto, namely Lochan and Paltu, also died unmarried, and thereafter Jagannath Mahto alone made Kotkar of the suit land after clearing jungle Jhari with the permission of ex-village village. It is also said that 2 sons of Jhari Mahto also succeeded their father and made Kotkar of 18.3 acres of land after clearing the jungle and came over the position. After vesting of Jamiandari in favor of state of ex-intermediary of the village, recognized the land of Jagannath Mahto, Sukan Mahto and Ugan Mahto as their layer, and after verification and operation of it, Gujarat rent for the suit land was assessed in the name of the Jagannath Mahto in the Sirista of the state of Bihar, White Kabil Lagam. Likewise, separate land was also assessed in favor of Sukan and Ugan for their respective land. Jagannath Mato also acquired 0.03 acres of land in village Bhaberi, Dhurki, in plot number 6226 of Khata number 14 from the ex-landlord and came in possession over the same and after vesting demand was opened which also suit land. It is further said Sukkan Mato and Ugan Mato partitioned their land mentioned above in the year 1985 and each of them came in their respective position of the land allotted in their separate takka. There was oral partition between the parties. As such, the rent received continued in jointness and both used to pay rent proportionately. Later on, Sukkan Mato died in the year 1991, leaving behind his widow, daughters, and sons, as mentioned in the genealogical, who inherited his property, came over the question. It is also said, wife of Jagannath Mato predeceased him much before issuance, and Jagannath being old, finding difficulty in maintaining himself, started living with his cousin, namely Tugan Mato, here in afterward plenty, in the year 1990, who used to look after his entire affairs. After reunion with Jagannath Mato, Tugan Mato continued in joint possession over the suit property and his sons till 4599. When Jagannath Mato died in jointness, and Ugan being nearest to Jagannath succeeded him and came in possession over the suit land uninterrupted from any side. It is also said in the plaintiff on the death of Jagannath Mato performed his last rites and Srath and during Srath, defendant number 1 and 2 came to the village and stayed in the plaintiff house, and while they were staying with the plaintiff, they stole away entire document of plaintiff which were in his name or in the name of Jagannath Mato, which were kept in box. It came in knowledge of the plaintiff in August 1990 that defendant number 1 had purchased the suit from Jagannath Mato, and hearing this rumor, plaintiff remained surprised when he made search about the document. Further, the plaintiff, along with his eldest son, came to Garhwa and made inquiries from the registry office through his tithe and applied for certified copy on 27/8/99. The certified copy of the deed was made available to the plaintiff. Then the plaintiff came to know that defendant number 1 got a gift deed executed fraudulently on 10/6/99 by impersonating Jagannath Mato, who died earlier than 10/6/99. That is their case loss. By impersonating Jagannath Mato. And prior to that, Lordship, they have asserted that we stole away the material, the file from the box when they came for the attending the SAR, but no FIR and any information was lost in that. Defendant, it is said that Jagannath died on there appears no question of executing deed in favor of any person, and the defendant with ulterior motive with a view to grab the land have got executed the deed number 2285/99 by false person. As such, the deed being fraudulent act of defendant is void ab initio, does not confer any right, title, and possession in favor of defendant. It is further said that the cause of action arose on 10/6/99 when the defendant got executed deed fraudulently in the name of defendant number 1 by falsely impersonating Jagannath Mato, and also subsequent to that date, the plaintiff suit has filed for declaring possession over the suit land and also for issuing mandatory injunction against the defendant. Para 3. In reply of claim, WS has been filed and it is stated the suit as filed is not maintainable. It is barred by law of statutory waiver and acquiescence and also barred by law of limitation and adverse position. Also, it is barred by SR Act since the suit is declaratory and consequential and it has been filed without paying ad valorem court fee. It cannot proceed and since the plaintiff has claimed.
That's right, we have seen the written statement.
Yes, Lord.
There is the issue regarding date of death of.
Issue number 7.
Issue number 7. There is no separate issue on date of death?
No issue. Separate issue has not been framed regarding death of the Jagannath Mato.
It will be covered under issue number 7.
7. Okay. Whether Jagannath Mato was separate from Ugan Mato, issue number 7 I am reading. Issue number 6 for whether there was a partition by meets and bounds between Ugan Mato and Sukkan Mato, and if there was a reunion of the family between them. Para 7 में है whether Jagannath Mato was separate from Ugan Mato and Sukkan and transferred his properties through a deed of gift, and that deed of gift is valid. That is the two main questions, 6, issue number 6 and issue number 7 that has been framed by the court. Issue number 8, whether the defendant number one was in the family of Jagannath since childhood as his daughter and served Jagannath during his old age, and defendant number two as his her command exercising the valid, exclusive and absolute right, title and possession over the entire property. These are the issues, Lordship.
एक second. The learned counsel, while reading the judgment, by placing the judgment of the learned trial court, has referred to the case of the plaintiff and has submitted that Sukan Mehto and his wife died issueless.
Sukan
Sorry.
Jagannath Mehto.
सुकन महतो और इनका रीयूनियन का भी तो कहानी है।
हाँ, यूं भी है। सुकन महतो और रुगन महतो का रीयूनियन का भी कहानी है।
हाँ, एक सेकंड। सुकन महतो and his wife died. The wife of Sukan Mehto predeceased.
Wife of Jagannath Mahto predeceased him.
सुकन महतो को भी तो वाइफ थी।
नहीं, सुकन महतो का यहाँ पर कुछ नहीं बोला है, उसकी तो वाइफ जिंदा है, बगमगिया देवी, वो सब्स्टिट्यूट हुई है।
Just.
इधर आया। Jagannath Mahto died issueless. And his wife predeceased him.
Reunion किसका है?
तो reunion है सुकन महतो, उगन महतो और जगन्नाथ महतो।
Okay.
That is their story.
The learned counsel submits that Jagannath Mehto died issueless.
Jagannath,
as per the plaintiff.
wife of Jagannath Mahto predeceased him. After the death of wife of Jagannath Mahto, Sukan Mahto and Ugan Mahto reunited. That is their case.
Just the learned counsel, by referring to the case of the plaintiff, has submitted that as per the plaintiff, wife of Jagannath Mehto predeceased Jagannath Mehto issueless. And consequently, Jagannath Mehto started living with Ugan Mehto, and therefore there was a reunion in the family amongst Jagannath Mehto, Sukan Mehto and Ugan.
Yes.
As per the plaint, the deed of gift was fraudulently executed in the name of Jagannath Mehto
in the name of Urmila Devi.
By impersonating Jagannath Mehto in the name of Urmila Devi,
Yes.
daughter of Sukan Mehto, by impersonating Jagannath Mehto. And such averment has been made on the basis that Jagannath Mehto had died on 4/5/1999,
Yes, sir.
and therefore he could not have executed the registered gift deed on 10/6/1999
In favor of Urmila Devi.
in favor of Urmila Devi.
Now, the defendant case is Lordship. Defendant case is para 3 से है, ये para page internal page 4. Sixth line. That the properties of Ugan Mahto and Sukan Mahto were never partitioned by means and bound, and it is totally false to say Jagannath Mahto after the death of his wife while residing with Ugan. They have denied it. Jagannath Mahto was residing in his house and cultivating his entire land separately. It is said that Jagannath Mahto during the lifetime his wife brought the defendant number 1, Urmila Devi, in his family, and she served to them, and when she became marriageable, Jagannath got married her with defendant number 2, and after the marriage both the defendant number 1 and 2 started residing with him as his daughter and son-in-law, and both started looking after his affairs and cultivating the land belonging to him. It has specifically stated that Jagannath Mahto died on 4/8/1999. That is the case. The marriage of Urmila was performed by Jagannath Mahto, and after marriage, Urmila and her husband, they started living with Jagannath Mahto, and Jagannath Mahto died on 4/8/1999, residing with defendant, and he was never in jointness with Ugan Mahto. The jointness of Ugan Mahto has been denied. Till his death, Jagannath Mahto regularly paid the rent of Suk land, and after his death, the defendant who succeeded and acquired the right, title and position over the land of Jagannath became entitled to pay the rent after the death of Jagannath. Both performed his rights and served, and the story of theft has completely been denied. It is the claim of the Urmila Devi and Bansi that they have performed the Sraddh ceremony of the Jagannath Mandir. And theory of theft has been declined, has been denied. WS revealed that in fact the deed of gift was executed by Jagannath himself on 10/6/99, who appeared before the registry and who made his statement before him. The deed of gift was duly attested by the attesting witness, genuine. Since the defendant accepted the deed of gift and delivery of possession of the property of the defendant was known to everyone of the village and to the plaintiff, they came in possession of the suit land. Jagannath Mato also executed the deed duly attested by Sri Chitanda Montri Public Garba.
As per the case of the defendant, the properties of Ugal Mehto and Sugal Mehto were never partitioned by meets and bounds, and it was false to say that Jagannath Mehto, after death of his wife, was residing with Ugal. As per the written statement, the fact was that Jagannath Mehto was residing in his house and cultivating his entire land separately. It is stated that Jagannath Mehto during the lifetime of his wife, got the dependent number 1, Urmila Devi, in his family, and she served to them. When she became marriageable, Jagannath got him married with dependent number 2, and after marriage, both dependent number 1 and 2 started residing with him as his daughter and son-in-law, and both started looking after his affairs and cultivating the land belonging to him. It was specifically asserted in the written statement that Jagannath Mehto died on 4/8/99 while residing with the dependents, and he was never in jointness with Ugan Mehto. It was also asserted that the last rites of Jagannath Mehto was performed by dependent number 1 and 2. It was also asserted that the deed of gift was executed by Jagannath Mehto himself on 10/6/99, who appeared before the registry and who made a statement before the registrar. The deed of gift was duly attested by attesting witnesses, and according to the gift was a genuine document. It was also asserted that Jagannath Mehto had also executed a deed duly attested by Sri D. Ram, Notary Public, Garwa, on 22/7/99, and the date of death claimed by the plaintiff as 4/5/99 has been specifically denied and asserted that the date of death was 4/8/99, and therefore the gift deed executed by Jagannath Mehto was valid. That's it?
Yeah.
Finding difference. कोई भी इसमें से attesting witness has been examined?
No,
Attesting witness has not been examined.
Are they dead? Any reason for not examining the attesting witnesses?
No reasons have been assigned, Lordship, but the document which has been registered deed of gift, that was presented before the registrar, and after verification as per section.
The original was produced or certified copies?
Initially, the certified copy was produced, Annexure B and B by 1, the Exhibit B and B by 1, and during the pendency of the appeal, civil appeal, original deed of gift was exhibited, that is Exhibit I.
At the appellate stage.
At the appellate stage, was plaintiff.
That was admitted.
Admitted. No one has denied it.
The plaintiff or the defendant?
Defendant, they had
Defendant, they produced the original.
Defendant. But onus was upon the plaintiff to present it, Lordship, but they did not present. Thereafter, first the certified
How
copy.
will the plaintiff present it? Because you are the owner of the gift deed.
Maybe, but he has said कि we have obtained the
Original कहाँ से लेंगे?
नहीं, the certified copy तो plaintiff को भी देना चाहिए था ना. Certified
But
copy.
ultimately it has come on record.
Yes, it has come on.
Let's not bother about it.
Issue number 6 है whether there was a partition by meets and bounds between Ugan Mato and Sugan Mato.
How is it relevant for the substantial question?
Substantial question of
For
law
the
के लिए
substantial
दोनों नहीं. Substantial question के लिए
See, date of death thing.
Date of death का है.
What's the difference?
Date of death and deed of gift, whether that is
That's right.
valid or not.
What is the finding on?
Just I am explaining, Lordship. The plaintiff has exhibited only 2 documents, para 5. Exhibit 1, rent receipt, para 5, Lordship, internal page 5.
Yes.
Exhibit 1, rent receipt is standing in the name of Jagannath Mato. And exhibit 1 by A, last line, also rent it is standing in the name of Jagannath. So the exhibit which has been made by the plaintiff, that is exhibit 1 and 1 by A, that is the rent receipt which stands in the name of the Jagannath. There is no name of the plaintiff. Then para 6 lordship, on behalf of the defendant, following witnesses have been examined: DW1 Naka Yadav, so and so. Defendant has examined 8 witnesses. Defendant number 7, 6 is Urmila Devi, defendant number 1, 7 is Bansi Yadav, and defendant number 8 is Rajeshwar Prasad Yadav, who is brother of the Urmila Devi. And they have made exhibit lordship, exhibit A and exhibit A by 1 rent receipt, B and B by 1 bill, C to C1 Banda Parcha, D to D1 certified copy of Khatiyan, exhibit E gift deed number 2285 of 99, and exhibit F, that is in the trial court, it is gift deed number 2285/99. Exhibit F is certified copy of revenue receipt number 440 and decree of suit number 440, D H certified copy of appeal report. In the instant
What is the relevance of these 3 documents? Revenue suit?
Revenue suit, in fact, the revenue suit was filed by the Jagannath Mato and that was decided in his favor, lordship.
When did you file?
Before 2000, lordship.
Before 2000, but it has got nothing to do with the date of death.
Certified copy of revenue suit, that is 440 of 2000, that was filed by the Urmila Devi, lordship, and that has been decided in his favor, in her favor. Third round to prove the parties. Lordship may see now issue number 6 and 7 and 8, page 6.
Show me the finding.
Findings, lordship. Page 9 में आया है, page 9 में लॉर्डशिप. After evaluating the statement of witness of plaintiff, it is also pertinent to deal with the deposition of defendant DW1. It was Naka Yadav who had stated Jagannath Mato died in the year 99, and it was the month of Bhadra, and he participated in this raft. Witness says that Jagannath had solemnized the marriage of Urmila, and he had kept Urmila and his husband as Bhardama, and also transferred his entire property in favor of Urmila. Witness further says that Urmila is cultivating the entire property of Jagannath. Under para 8, witness deposed Zubin Yadav had adopted Urmila, but no adoption deed was prepared. Further, under para 9, witness says that Jagannath died in the year 99. Witness has stated in the para that Jagannath died in 4/5/99, and received in his statement here stated that he died in the year 99 in the month of Bhadra. Further, under para 11, witness the same annexed deed of gift, no paper was prepared by Jagannath. Thus, from the statement of this witness, who has been examined on behalf of the story of death, which either held on 4/5/99 or on 4/8/99 doubted. It is further doubted that beside deed of gift, no paper was prepared in favor of Urmila. DW2 also said that Uggan and Sukkan were cousins of Jagannath, and Jagannath died in the year 99 in the month of Bhadra. He has stated Jagannath had adopted Urmila and himself had solemnized her marriage. Witness has stated that the false claim of Uggan that he never ever remained in jointness with Jagannath. Para 7, witness has stated Jagannath had adopted Urmila about 10 years earlier prior to his death. Further, it is said under para 6, Urmila marriage was held in the year 95, as claimed by both the parties. Jagannath died in the year 99, as such it is for sake of our being presumed to Urmila was adopted, then adoption might have taken place in the year 89. Thus, both these statements are self-contradictory. Under para 10, specifies that Jagannath died on 4/8/99. DW3 has stated the same story, and Jagannath died in the Hindu calendar month of Bhadra. He participated in the Sraddh of Jagannath. Under para 3, he has stated the entire property of Jagannath belongs to Urmila, and the decision reasons also took place in favor of Urmila. In cross-examination under para 7, witness has stated the marriage of Urmila was solemnized at the age of 15-16 years, and the marriage was solemnized by her father. Under para 17, witness has stated that he is not knowing that actually how many papers were executed in favor of Urmila. He does not know. Under para 23, witness has stated that after 12 years of the marriage of female, the adoption bill was prepared, and beside this witness actually put his signature. He has denied to remember. This witness has stated a new story of adoption deed. Thus, from the relation of material as done from both the parties, the fact becomes more complex. DW4 has stated that Ugan and Sukkan were cousins of Jagannath, and Jagannath had died. He has cited the date of death as 4/8/99. Under para 2, witness has stated Jagannath had adopted the daughter of Sukkan, and he himself has solemnized her marriage with Vansi Yadav, resident of Chhattisgarh, and after her marriage he was kept as husband. Urmila, who is told to be residing with Jagannath to look after the agriculture of Jagannath, under para 17, witnesses that the marriage of Urmila was held at the age of 17-18 years, whereas other witnesses have stated the marriage of Urmila was solemnized at 15-16 years. Para 15 reveals the adoption deed was prepared after the marriage of Urmila, whereas other witnesses have stated the deed of adoption was prepared prior to marriage of Urmila. Thus, even from the statement of the date of death of Jagannath, the story of adoption and the time of marriage is not in sequence. DW5 is formal witness who has proved rent receipt. DW6 is the defendant number 1, Urmila Devi, and who claims that she was adopted by Jagannath. She has stated that her uncle Ugan has filed the suit, and her father was two brothers, Ugan and Sukkan, and their properties were divided in between them. As per the statement of this, Jagannath had no issue as such. He kept to his respective victim from childhood, and Ugan Mato plaintiff had never participated even in Sraddh Kram of Jagannath. He has further stated Jagannath has executed deed of gift and will in her favor for his property, and after the death of Jagannath by revenue titles of her name surfaced in the revenue register, and she started paying rent. In cross-examination, she has again repeated the same story. Jagannath has transferred property by deed of gift at the registry of his Varma in his favor. Under para 10, witness has said Jagannath died on 8/4/99. Thus, even from the statement of this witness, which main context is the date of death, Jagannath becomes complex, as stated by this witness, Jagannath died on 8. Thus, even from the statement of this witness, the story of execution deed becomes complex. DW7, he is husband of defendant number 1 and also defendant number 2 of this suit. He has stated that same fact, and at last part, Jagannath died on 4/8/99, and he himself performed his Sraddh, and he has specifically denied the date of death of Jagannath as 4/5/99. Under para 8, witnesses that his marriage was solemnized in the year 1995. Further, under para 14, witness has stated that after the death of Jagannath, his entire property was managed by Urmila as from his childhood. Jagannath has kept her well-being. He has denied about the adoption of Urmila. Thus, even from the statement of the story of adoption, other facts become complex. Under para 18, according to this witness, will was executed on 22/7 and deed of gift was executed on 10/6/99. Now there remains last witness DW8, who has stated DW8 like
This
that.
falls here for me.
Yes, Rossi?
He has stated about two documents.
Yes.
One is will dated 22/7/99.
Yes, sir.
That was a notarized document. This has been exhibited. 22/7/99 has been exhibited.
इसमें बिल का यह है उसके लिए अलग प्रोबेट केस है तो चल रहा था।
प्रोबेट केस क्यों चलेगा जब ऑलरेडी गिफ्ट हो चुका है?
नहीं,
जब ऑलरेडी प्रॉपर्टी गिफ्ट हो चुका है, where is the question of a probate case?
Deed of gift the execute that was in respect of property of 4.02 acres only, and in deed of will है उसमें जो है सो remaining property है उसको दिया है। तो here
this exhibit, which is that exhibit? ये this one 22/7/99.
22/7/99 का अलग से केस चल रहा है।
Has been exhibited or not exhibited?
No, not exhibited in this. Now let's see.
No. It is there. Exhibit B. Exhibit B.
Oh, sorry. Exhibit B to B by 1 B.
Exhibit B में ये property included है कि नहीं? ये बताओ।
नहीं है। Exhibit B जो will है, एक deed of gift है in respect of property of 4.02 acres, और will में जो है उसमें जो है so remaining property जो है तो उसको दिया गया है will।
Let us see exhibit B.
Yes, exhibit B is there. Exhibit B to B.
Exhibit B and B by 1.
Yes, yes.
Exhibit B किसने prove किया?
यहाँ एग्जीक्यूटिव भी है सो प्रूव किया है राइट्स ऑफ प्रसाद यादव DW8 है सो प्रूव किया है इसको DW8 का गवाही देखा जाए गवाही में राइट्स ऑफ प्रसाद यादव डिपेंडेंट नंबर साक्ष्य संख्या 8 पैरा 3 में पैरा 3 यह कि दिनांक 10 जगन्नाथ मंदिर बख्शी किया था उसी दिन एक दस्तावेज कमलकांत टाइप से मेरे सामने दिखाया था कि बख्शिश वाली जमीन के अलावे सभी संपत्ति मेरे मरने के बाद उर्मिला देवी की होगी। जगन्नाथ प्रसाद यादव ने अपना बाएं अंगूठे का निशान एंड उसको है 51 है सो नेक्स्ट है पैरा 4 में पैरा 5 में है कि जगन्नाथ बख्शी की मृत्यु 4/8/99 को हुई थी। बख्शिश वाला संत उर्मिला जी के हक कब्जा में चला रहा है। Now, Lordship.
Then ultimately, what did the court hold?
पेज 8 में आया जाए तो इंटरनल पेज 8 में ना
Internal page 30. 8 from the part.
हाँ इंटरनल पेज
30. As evidence adduced, documents produced, and documents available on record. It is even
as evidence adduced, documents produced and documents available, it is even apparent on the face of exhibit B by 1 that interpolation has been made over it, which is apparent even on first page. As such, mere on producing the document evidence produced after evaluating entire material is brought on record is my considered opinion. This issue partly goes in favor of plaintiff, and accordingly so far will and deed is concerned, up to this extent it is decided in favor of plaintiff. Then issue number 1 and 2, with respect these two issues as per evidence brought on record and material produced which is maintainable, and the plaintiff, who is one of the ancestors of late Jagannath, has valid cause of action. As such, these two issues also.
There is no finding regarding date of death.
There is no finding. Even by the affiliate court, there is no clear finding regarding date of death. And Lordship may see it.
Let us see the appellate court study.
Yeah, Justice, order. What is the order, Lordship? That is also important of the title suit. Page 13, the last paragraph. Issue number 6, it has been decided against the plaintiff. This suit, so far declaration of gift and will of Urmila favor is concerned, these documents are declared as not enforceable, and so far he has used the word enforceable. He has not said it is void ab initio or forced. not enforceable. This part is very important. Why it is not enforceable? The reasons has not been assigned by the learning court. And so far as the right title and possession of plaintiff and defendant are concerned, it is ordered that the property of Jagannath will devolve in favor of legal heirs in proportional to their respective shares. As such, this suit is partly decreed in favor of plaintiff, and the property of Jagannath will devolve in favor of their next legal heirs in proportion to their share and right through process of law. This was not the prayers made in the plaintiff lawsuit. And the London court below track in title suit, they have traveled beyond the prayers made in the plain and created a third right against the plaintiff lawsuit, which is not at all permissible.
What is the judgment in the?
Yes. Now let's see the appellate court judgment. Lordship may see. Running page 37 may be seen, Lordship. The same thing has been repeated. And internal page 39, Lordship. Page 39 of the appellate court judgment running page. Just I am reading in the.
Is there any finding regarding date of death?
No finding, Lordship. Even in the title suit or in the title appeal, there is no finding, clear-cut finding with regard to date of death. Only they have said it is confusing, complex. Lordship may see page 39, internal page 5 of the appellate court judgment. Just I am reading 7th line, Lordship. Internal page 5 of the appellate court judgment. Running page 39. Further, the plaintiff, along with his eldest son, came to his Garba and made inquiry from the registry office through his tithe and applied for certified copy in 27/8/99. The certified copy of the deed was made available to the plaintiff. Now they have said the certified copy of the deed was made available, but what prevented the plaintiff from exhibiting it before the court below in the title suit? There is no reasons has been assigned for this. Yes, Lordship.
Need not be once you are already.
Why I am saying so, Lordship? If plaintiff is claiming that the deed of gift is a manufactured document and by impersonating Jagannath Mahaprabhu it has been, onus lies upon the plaintiff to produce it, Lordship. First, plaintiff has to prove his case. He cannot take the defense that the defendant will do it. Now, thereafter it is said that Jagannath died on 4/5/19 as there appears no question of executing deed in favor of any person, and the defendant with ulterior motive with a view to grab the land have required to execute the deed number a false person. Who is this false person? They did not say so.
Need not be. A person, it is enough to say that he was dead. Who was the person who had actually impersonated?
Yes, Lordship.
Right? It is not for this.
Yes, Lordship, but even then.
कौन आके उनकी जगह खड़ा होके डीड एग्जीक्यूट करा? ये नहीं कोई.
ठीक. उसका देखा जाए. Cause of action arose on 10/6/99 when the defendant bought a executed deed fraudulently in the name of defendant by falsely impersonating Jagannath Mahaprabhu, also subsequent that the plaintiff suit has been filed for declaring possession of the suit and also producing mandatory declaration. Now, Lordship, they have again repeated the same thing, the story of theft, etc. And now, Lordship, issues which were framed, now the defendant, the plaintiff witnesses, document exhibited, defendant witnesses, defendant exhibited. Now, Lordship may see page 43, internal page 9. Internal page 9. Exhibit I, Lordship. Original gift deed.
Page number?
Page number 9. Internal page 9, running page 43.
That's right, it has been produced.
Original gift deed I.
You come to page number 20.
Page number
20.
20.
22. 22 bottom body and exhibit B.
Exhibit B is a deed of gift and exhibit D1 is a deed of gift which was notarized by
ये है 22 है page 22 है exhibit B is deed of gift and exhibit B1 is deed of gift which was notarized by notary Jitendra. Exhibit E is the certified copy of registered duty. Other documents such as certified copy of the order of revenue suit as decided in section 87 is the order of revenue code and the decree followed by this order is also decree of revenue code. In this respect, the citation and mandate of law relevant to it decision the deed of gift is very important document on which basis the transfer of property in favor of defendant's claim required to be effected. The original copy of deed has been filed from the defendant side in the appellate court and was marked exhibit I. No convincing reason for non-filing original deed of enlargement has been offered from the defendant side. It has consistently been argued that when who asserts some point, the onus lies upon him to prove. Yes, it would be important to state that both the parties are claiming the property. The onus shifts from one party to other depending on the assertion of point. From the statement of implied witnesses point on behalf of both the parties, the date of death has not been substantiated. Rather, even some witnesses defendant stated different. The Evidence Act section 68 demands that if document is required by law to be attested, with which shall not be used unless it is one attesting witness has been called for the purpose of proving its exclusion. Since there is very important document, so the mandate of law is required to be complied. The parties concerned, it may be further said merely marking of document will not be sufficient for the consideration of the document. Admittedly, document has been filed, but its contents have not been proved in accordance with law. Section 123 of the Transfer of Property Act 82, with regard to gift or transfer, must be affected by registered witness signed by or behalf of donor and attested by at least 2 witnesses. Thereafter, Lordship, after skipping 4-5 times, in the same case, it is. Yes. Just I am making Lordship my submission. Huh? नहीं हम सेक्शन 34 ऑफ द इंडियन रजिस्ट्रेशन एक्ट को दिखाए हैं सेक्शन
अब जजमेंट लिखें वो काम नहीं जजमेंट हमारे काम
नहीं लॉर्डशिप जस्ट सेक्शन 34 थोड़ा सा पढ़ दे रहे हैं इंडियन रजिस्ट्रेशन एक्ट
प्रिजम्पशन पे बोलेंगे ना
नहीं हम पढ़ देते हैं ना इसको लिखा जाना सेक्शन 34 इंक्वायरी बिफोर रजिस्ट्रेशन बाय रजिस्ट्रिंग ऑफिसर सब्जेक्ट टू द प्रोविजंस कंटेन्ड इन सो एंड सो documents shall be registered under this act unless the persons executing such documents or their representative, assigns or agents authorized as the courts appear before the registering officer within the time allowed for presentation under section 23, 24, 25, 26. Then provide owing to urgent necessity कर रहे हैं तो 3B पढ़ रहे हैं 3B satisfy himself as to the identity of the person appearing before him and alleging that they have executed the document. So, when the registry has been made before the registrar.
Yes, now you tell us. There is no finding. You made a specific statement that Jagannath Mehta died on a particular day. Who had to prove it?
I have to.
You had to prove it?
Yes, yes.
You have not
That's
proved
why
it.
argument.
Okay.
Tomorrow I will assist.
Why? Yes, yes. But queries are very clear.
How queries? I will. I have.
Every time you argue,
I have heard very patiently.
Now you prove the case.
I have heard very patiently. I will respond all the points.
आप हमारा क्वेरी तो समझ लीजिए.
हाँ क्वेरी हम क्वेरी विजिट के आप समझ गए.
आप समझ गए.
हाँ कि
आपको पता है लॉ क्या है. इसलिए समझने के लिए कुछ बोलने का जरूरत नहीं.
उसको आंसर हम कल देंगे.
सीधा सीधी बात है.
क्योंकि कुछ कंपाइलेशन भी हमको देना होगा.
सीधा सीधी बात है. You made a specific assertion that he died on a particular date.
कि
एक second. You made a specific statement that he died on a particular date. Right? And he's not a stranger, he's your family member only. Right? And both the courts have returned a finding that both of you could not prove the date of death. Correct? Then, in case of, it is further not in dispute that this document was, this gift deed was duly registered. You did not exhibit it. Right? You did not exhibit it. Although you challenged the gift, but you did not exhibit it. They have initially exhibited the certified copy. The original was exhibited later. Correct? Now, in absence of date of death proved by either parties, what is the consequence of the register? नया जजमेंट लेके आइए, आप बहुत बार साइड किए हैं, आप वो तो पहली बार आए हैं इसको, आपको तो पता। और कब तक गिफ्ट डीड है?
मेरा गिफ्ट है 10/6/99। 10/6/99।
ठीक है, इतना ही सब बात है, बस जजमेंट लेके। आप जजमेंट खोजे नहीं तो क्या करेंगे? थोड़ा मोबाइल निकालिए, व्हाट्सएप चलाने की बजाय कुछ और खोजिएगा, मिल जाएगा। अभी नया जजमेंट आया, प्रिजम्पशन इन कनेक्शन विद ए रजिस्टर्ड डॉक्यूमेंट, एग्जीक्यूशन पर प्रिजम्पशन, उसके रिसाइटल पर प्रिजम्पशन, लेकिन एग्जीक्यूशन पर प्रिजम्पशन। There is a presumption so far as the execution of the registered deed is concerned, and this presumption
is debatable.
It was a debatable presumption, which they have not been able to prove the date of death was prior to the date.
ठीक है, उसको कल दिखाते हैं इनका इनका।
अच्छा, और भी लिख लीजिए इसमें, ठीक है। The learned counsel for the appellant had submitted that the learned trial court did not return any finding with respect to the specific date of death of Jagannath. He has also submitted that the plaintiff claimed that Jagannath Mehto had expired on 4/5/99, and a specific assertion was made to that effect, but they failed to prove this fact. On the other hand, the defendant claimed that the date of death was 4/8/99, and even the defendant could not prove this fact before the court. The learned counsel has submitted that in case where a plaintiff has made a specific assertion regarding date of death, it was for the plaintiff to prove it. And over and above this fact, he has stated that the gift deed was admittedly a registered document, and there is a presumption in law with respect to its due execution. And therefore, and accordingly, he has referred to section 34 of the Indian Evidence Act.
Indian Registration Act.
Registration Act.
Indian
Of Indian Registration Act. Of the Registration Act. Indian
Registration Act.
The learned counsel has then referred to the judgment passed by the learned first appellate court, and he has submitted that the learned first appellate court has specifically recorded that none of the parties have been able to prove the date of death of Jagannath Mehto. However, by considering the gift deed, the learned first appellate court recorded that the original gift deed was produced before the first appellate court and was marked exhibit capital I, but there was no convincing reason for not filing the original deed of gift before the learned trial court. However, the learned first appellate court was of the view that the witnesses to the gift deed having not been produced before the court, the attesting witness to the gift deed having not been produced before the court, mere exhibiting of the original gift deed was not sufficient. The learned counsel submits that the registered The certified copy of the gift deed from the registry office was produced before the court. And
Exhibit E.
exhibit
E. E.
E.
E.
Exhibit E. Exhibit B is the deed of gift.
Exhibit B has a will है also.
इसमें लिखा है exhibit B is the deed of gift. Was produced before the court. वो हम लोग check करेंगे. And in view of the presumption in connection with registered document, the learned court was not justified in holding that the gift deed was invalid.
एक 123 जो ट्रांसफर ऑफ प्रॉपर्टी एक्ट का है उसमें साफ बोलता है ट्रांसफर हाउ इफेक्टेड फॉर द पर्पस ऑफ मेकिंग ए गिफ्ट ऑफ इमोरल ट्रांसफर मस्ट बी अफेक्टेड बाय रजिस्टर्ड इंस्ट्रूमेंट साइंड बाय ऑन बिहाफ ऑफ डोनर अटेस्टेड बाय एटलीस्ट 2 witnesses for the purpose of making a gift such as moreover the transfer may be affected either by registered instruments signed as aforesaid or by delivery. That part has been complied with law.
The learned counsel has also referred to section 123 of the Transfer of Property Act and has submitted that all the ingredients of transfer through gift has been satisfied in the case. The gift deed being registered document and the date of death of Jagannath Mehta was not proved by either parties. The learned courts were not justified in holding that the gift deed was not valid.
And section 68 of the Indian Evidence Act says, proof of execution or required by law to be attested. If a document is required by law to be attested, it shall not be used as evidence until one or 6 witnesses has been brought for the purpose.
Also referred to section 68.
Provided that it shall not be necessary to call an attesting witness in proof of execution of any document not being will, which has been registered in accordance with the provision
The
of the
learned counsel has also referred to section 68 of the
Indian Evidence
Act to submit that except in case of will, when the document is registered, then there is no need to call the witness to prove the will. The learned counsel for the respondent submits that he shall advance his arguments tomorrow as trustees. ठीक है? रजिस्ट्रार को आने की जरूरत थी, ये भी एक रीजन है इसको देखिए. Was the registrar required to be examined?
In fact, daily solve there's a registry होता है. Registrar, how he will remember the who has deposed the person when he is sitting in a court, and they usually ask, who are you? Have you received the money? Have you signing the document without any person, threat or pressure from any side, free will? That is the 3-4 questions which the registrar put before the seller lordship, and after that the deed for the of seller or any deed is executed. That is the common practice. So that is a public document. In fact, after registration, it is a document.
भी आप जजमेंट तो खोजते नहीं है ना, हम आपकी तरफ से जजमेंट नहीं खोजेंगे ना, और आपको नहीं मिलता है तो कोई बढ़िया जूनियर लगाइए अपने साथ. You engage a junior, he will give you immediately. 5 मिनट नहीं लगेगा उसको खोजने. आप खोज नहीं रहे हैं, ये टेक्नोलॉजी का जो हिच है ना यूज करने का, इससे दूर रहिए. आप खोलिए और आपको मिल जाएगा. आप टाइप तो करिए, व्हाट्सएप से बाहर निकलिए, आपको मिल जाएगा. नेट पे खोजिएगा, मिल जाएगा. I'm telling you.
So, consider myself very fortunate that I have got a good lordship. So this part I will do it.
आपको मिलेगा जजमेंट्स. कुछ जजमेंट्स में मैंने भी साइट किए हैं, वो मिल जाएगा. आप भी खोजिए.
Item 11 second 325 of 2019.
to inadvertence of bona fide mistake. The last
Bona
order,
fide mistake.
the last order could not be complied within the stipulated time. Notice has been issued to respondent number 8 works. The queries have been filed.
Dismiss हो गया.
The queries have been filed, but not within the stipulated time.
क्या करेंगे? It's already been dismissed.
आइए ready किया जो
आइए क्या जिससे?
restoration
Restoration आइए से नहीं होगा. Restoration का लंबा प्रोसेस. आइए से.
then not I will file a separate application for some time will return.
I do not. आपका ये सब जो है ना प्रॉपर नहीं है.
Queries have been filed, but not within the stipulated time. These are necessary parties.
तो क्या करेंगे?
Humbly pray, Lord.
Yes, respondent, what do you have to say to this? I have copy दिया?
हाँ ये
क्या बोलना है?
I want to file the reply. I will
File it.
object. I will object for
आपने कब फाइल कर दी?
File
24
file
को
it within Lord.
फाइल तो
आप
की
फाइल कर दीजिए. आपने कब रिक्विजिट फाइल किया?
19th को
19 को. आपको कब तक फाइल करना है?
रेगुलर तो फाइल हो गया.
कितने दिन में आपको फाइल करना था इस बार ऑर्डर?
2 weeks.
ऐसे नंबर की 25 और 2019. The learned counsel for the applicant files a utility application in connection with respondent number 8. A copy has been served upon the counsel for the respondent. He prays for time to file a response to the interview. फाइल करें, इनका देकर इनको इंस्टीट्यूट करें. आपको कितना टाइम चाहिए?
2 हफ्ता ज़्यादा नहीं. धनबाद से बुलाना पड़ेगा उसको.
At the request of the counsel for the respondents, court this case on 30th of October.
38.
Please,
Obliged.
the reply should be filed latest by 20.
I am for the 2-3-11 only, ma'am.
So,
2-3-11 I am for the
बाकी
respondent.
लोग कौन? बाकी लोग नहीं आते?
बाकी लोग का तो सब नोटिस गया, कोई आया नहीं, एबेट कर गया, बहुत सा है इसमें. लास्ट ऑर्डर में लिखा हुआ था कि 2-3-11 की तरफ से हम लोग हैं बस.
इतना बड़ा गलती कैसे करते हैं? आप समझ रहे हैं? कहाँ आप फंस गए? बहुत गलत फंस गए. हो सकता है आपको CNP फाइल करना पड़ेगा. हमको नहीं लगता है कि ये नहीं. It's a waste of time.
पूरा सेकंड में डिस्कस करना है. respondent was late business.
तो रिस्पॉन्ड नंबर 8 के अगेंस्ट में डिस्कस हो गया. ठीक है, यू आर्ग्यू द केस. ऐसा क्या है?
Therefore I have filed IAS.
आईए से नहीं. I do not know लेकिन रिस्पॉन्ड आईए से नहीं होगा बिकॉज बहुतों के अगेंस्ट में सर्व हो गया है लेकिन दे आर नॉट अपीयरिंग. तो उसका हम लोग क्या करेंगे? वी डू नॉट नो इंटर पार्टी क्या सिचुएशन है. CNP ही फाइल होगा. वी आर जस्ट वेस्टिंग योर टाइम. ठीक है, वी विल सी ऑन द नेक्स्ट डे. बट आई डोंट थिंक दैट दिस इज अदरवाइज लीगल. CNP फाइल होता है ना सबका रेस्टोरेशन.
एक का तो छोड़ दिए,
हमारे पास क्या है?
एक ऑलरेडी छोड़ दिए. 10 नंबर का मालूम पास की थी ऑर्डर, एबेट कर गया है, उसका छोड़ दिया. उसका कुछ नहीं किया.
लोअर कोर्ट में वेट कर रहे हैं.
Let's see. If
नहीं,
you
यहाँ
raise
पे
an
क्या
objection that it is not maintainable, we will decide
हाँ,
whether
yes,
it is
I tell
maintainable or
them.
not maintainable.
2 दिन पहले दिए हमको कॉपी. छुट्टी के 2 दिन पहले दिए हमको, 24 तारीख को.
CNP फाइल करना नहीं होगा.
Obliged.
Item 12, 7-16 of 2022.
In this case, I also might play for not playing or
Adjournment request है. Advance. आदमी. क्यों आपको adjournment चाहिए?
Due to some personal
ये कोई reason है? Adjournment का?
due to some personal difficulty.
What personal reason? बॉस लगा के आपका adjournment किया. Essay number 16 of 2020. The Learned Counsel for the Appellants seek adjournment and advance notice seeking adjournment has been circulated. Did you receive?
Yes, madam. I have been informed.
बताइए कब करना? Any objection?
No.
With the consent of the Learned Counsel for the parties, post this case for final hearing. The final disposal. On final disposal under the same meeting on 13th October.
Item 13, First April 46 of 2023.
Short adjournment.
Response. Appellant is seeking adjournment.
Delegation.
You have also circulated an advance notice.
I don't think.
On the last date, the respondent had undertaken that he shall not seek adjournment. Now the appellant is seeking adjournment. क्या करें?
Second half and it will be taken up.
Second half is start. Right. Second half is same नहीं है. यहाँ पे हर बार जो है ना नया कहानी से adjournment होता है. पिछली बार counsel from Patna is to us, Mr. Mahesh Prasad.
That is, yes.
फिर क्या?
After that, I was engaged.
बस यही ना कहानी है. काउंसिल का नाम लिखाते रहिए. काउंसिल का नाम लिखाते समय नहीं समझ आता है.
उनकी डेथ हो गई.
फिर क्या?
Learned counsel who was supposed to come from Patna.
Mr. Mahesh Prasad.
Yes.
कब करिएगा बताइए.
Tomorrow or any day.
Yes, respondent, when do you want to do it? When do you want to do it?
You can.
Any day your ladyship, subject to ladyship's convenience, except for tomorrow.
It is first appeal, right?
Yes.
What is the matter?
Yes.
कम से कम matter तो बताइए.
Eviction suit file किए थे.
Eviction suit. What eviction suit? Eviction suit तो यहाँ second appeal में आपको.
Permissive occupation था respondent का.
permissive possession.
Lease property होगा उसमें. उनका क्लेम है कि रिलिंक्विश कर दिया था इन
How many witnesses are there?
our case is that वो फोर्स डॉक्यूमेंट के बेसिस पे उन्होंने किया था. फोर्जरी के लिए क्रिमिनल केस किया था. क्रिमिनल केस तो उसमें यहाँ पे सीआरपी में क्वैश हो गया था, बट सम डॉक्यूमेंट्स reported from forensic lab that they are forged. The already she was pleased to summon those documents. We have filed an application for marking these as exhibit.
So those by additional evidence.
Additional evidence.
You have responded to the interlocutory application.
No, Your Ladyship has very pleased to foreclose our right to respond.
Okay.
So the document has been filed by them, and we will argue at the final stage whether it can be utilized, whether it can be placed into service or not.
FA number 46 of 2023. एक ही कंडीशन में आपका जजमेंट है. आप पूरा रिटन सबमिशन बनाएंगे.
Yes.
Including the evidence of the witnesses, oral, documentary, सबका आपको एकदम आपको complete written submissions on both the sides. On both the sides, right? And then please ensure that it is strictly as per records. एक भी अगर सेंटेंस में हमको बियॉन्ड रिकॉर्ड मिल गया तो आई विल इम्पोज वेरी heavy cost. Nothing should be beyond record, even one sentence. FA number 46 of 2023. The learned counsel for the parties are present. Counsel for the appellant, she seeks adjournment. The counsel for the respondent has joined the proceedings through virtual. With the consent of the learned counsel for the parties, hold this case. Final disposal?
Yes.
Hold this case for final disposal on 15th October. हो जाएगा?
जी.
On 15th October 2025, the learned counsel for the parties have undertaken to prepare
15th October, Your Ladyship. See, Your Ladyship, I've got some difficulty, Your Ladyship, on 15th. Could it be 14th?
Then it may be placed after Diwali.
देखिए फर्स्ट अपील शुरू होगा ना तो हम तो डेट टू डे सुनेंगे. इसीलिए
That's
15 को नहीं है
right.
तो 14 को मत कराइए. तो आफ्टर दिवाली करते हैं.
ठीक है.
On 11th of November, the parties to file their a short synopsis of arguments based on materials on record, latest by 3rd of November.
So 18th November दिया गया.
11th of November. Yes.
Ladyship, please.
और सॉफ्ट कॉपी प्रोवाइड कर देंगे हमारे कोर्ट मास्टर. सॉफ्ट कॉपी प्रोवाइड कर देंगे अंदर
जी. तो 11th November का गया.
हाँ 11.
Much obliged.
Item 40, second appeal 57 of 2023.
Appellant.
Lordship, the last opinion Lordship, this was admitted, order dated Lordship, 13/6/2025. The notices were sent Lordship.
Notice is complete.
First time after it is come.
What is the matter?
Lordship.
It's a partnership.
No Lordship. For the interest of right and interest of the plaintiff.
Then service of notice upon the close family member should be sufficient.
Technically Lordship will be sufficient as whatever Lordship pleases. Close means any relation has been given.
Relation has been provided. That 1, 5 and 6 received by granddaughter who lives jointly.
Grand.
Respondent number 2 received by daughter who lives jointly.
That can be recorded.
3, 4 and 7 received by niece who lives jointly. Counsel for the appellant is present. Notices were issued upon respond number 1 to 7, and as per the office note, the notice has been served upon the close family members who live jointly. Counsel for the appellant has stated that the notice may be accepted as validly served. Considering the submissions, the notice upon the respondents is accepted as validly served. However, nobody has entered appearance on behalf of the respondents. At the time of issuance of notice on 13/6/2025, the matter was directed to be posted for final disposal on 28th of July 2025. अब उसमें हमारे पास
हाँ एक डेट पूरा कर देख लो
if anyone there
I'm sorry.
1 to 7
Not to 1 to 7. I would be appealing on behalf of respondent of 1, 2, 3, 5 and 6.
Now is
1,
2, 3, 5 and 6. As far as respondent number 4 is concerned, he has died already, sir. And I have prepared one supplementary affidavit also. I would be filing giving the details of the legal heirs. And as far as respondent number 7 is concerned, inadvertently one of the family member has received notice for respondent number 7. We would not be representing them. However, as per the office report, the service is complete. But हम उनको represent नहीं करेंगे. गलती से family member 20-year-old daughter has taken the notice for respondent number 7.
अब ले दिया है तो किसने गलती से
मेरे
तो उनका करंट एड्रेस देंगे ना रेस्पॉन्ड नंबर 7 का
No,
कहाँ है?
क्या है ना? From the record, I am finding that he was also the plaintiff lordship in the original suit, and we are also the plaintiff. Two plaintiffs were there. One plaintiff has preferred the second appeal. It might be from our side.
ओके तो रेस्पॉन्ड नंबर 7 को दोबारा नोटिस जाएगा. एड्रेस इज करेक्ट?
एड्रेस तो
हाँ एड्रेस
आपको पता होगा ना?
इनके यहाँ पता नहीं क्या वो तो एड्रेस भी नहीं था. इनके यहाँ चला कैसे?
मेरे यहाँ चला गया आ गया गलती से ले लिया गया.
ये कहाँ जाएगा?
तो जो एड्रेस दिया हुआ उस पे जाना चाहिए. उसी पे गया होगा लेकिन however how it is they have received I don't know because the address is different in my memo.
ओके देखिए इसका जो है ना फिर से
नहीं एक ही गांव के दोनों एक ही गांव.
फिर से प्लीज टेक इट.
वहीं के हैं.
Counsel for the parties are counsel for the appellant is present. Mr. नाम बताइए.
चंचल जैन.
Mr. Chanchal Jain, advocate, has submitted that he has received wakalatnama on behalf of respond number 1, 2, 3, 5 and 6.
Yes.
And so far as respond number 4 is concerned, he has expired. The learned counsel submits that an appropriate petition का आइए करके
सप्लीमेंट्री में रेडी बस
अच्छा ठीक है.
इसको हम आज फाइल
Just a
करेंगे.
moment. He undertakes to file an affidavit bringing on record the date of death
Yes.
of respond number 4
Yes.
and also the details of legal hearing
Yes.
successes so that the appellant may take up.
Yes.
With respect to respond number 7, the learned counsel has submitted that as per office note, niece
One Anshu Gupta has received.
one Anshu Gupta has received the notice, but the notice has been wrongly served upon her. Besides that, the appellant may have to take steps for fresh steps of issue notice to respond number 7.
Village is same lordship. Every
Yes.
address is also same.
respondent number 7 through the concerned police station. Police station.
Yes.
For which requisites be filed by the appellant by Friday.
By
Friday. By Friday. Post this case on November 4th, awaiting service to police.
And in the meantime, Lordship, if they file, Lordship, I'll file IA also.
We will file it today.
Copy it so that I can file IA for the same.
Yes. Much obliged.
आपको respondent number 4 का भी तो legally है सब वकालतनामा अगर नहीं रहा
मिलेगा तो हम हुजूर आई विल डेफिनेटली
तो अगर मिलता है तो आप आईए के साथ भी फाइल कर सकते हैं। अब तो यहाँ फाइल कर ये कौन फाइल करता है आपके
if it the
respondent number 4 के ही कोई बच्चे फाइल कर रहे हैं
नहीं we are only respondent number 2 की तरफ से we are only informing you
they belong to the same family
yes they are the same family
जल्दी करना है तो
डेफिनेटली
वो रेडी रखें तो जैसे सब्स्टिट्यूट होगा ये अपना फाइल कर देंगे बिफोर दैट दे कैन नॉट फाइल
अच्छा
Item 15, second to 238 of 2023.
Yes, Apina.
Yes, leadership was pleased to admit this appeal on 21st July. Two substantial questions of law were formulated.
Date
21st July 25.
21st July.
Whether the evidence of the defendant have been taken into consideration to determine the relationship of landlord and tenant despite the defense of the defendant having been struck off at a later stage. And the second one, whether even if evidence of the defendant is to be excluded from consideration, the judgment of the landlord or can still be sustained solely on basis of plaintiff's evidence.
So there was a suit for eviction on the ground of default and subletting, in which the defendant.
Could you please give me the suit number?
Yes.
Eviction suit number 16 of 2011.
Default and
Sublet.
then the defendant appealed.
Yes.
Filed WS.
I filed WS and in course of the independence of the suit, an order was passed under section 15. I did not comply with that.
What
So
is
my
that order? Date of order?
yes. We mentioned para 19 of the judgment.
11 February 2020.
11 to 2020. Order under section 15 to pay rent. Right?
No, striking of the defense. Order was.
What is
Order
the date
dated is
Order was
2120.
Sorry?
3rd January 2020.
Okay. 3/1/20 was the order.
Order.
When
And
was the struck off?
11 February 20.
11 to 20. Defense struck off.
Defense.
Any evidence left in the meantime?
Before that evidence was left.
Whose
Because
evidence was left?
defendant's evidence. Plaintiff's evidence was already concluded. So, your leadership, I can't say with exact clarity when the date.
No, the case was fixed for argument, and that point of time this application was filed, and thereafter the evidence, their defense was found. So prior to that, evidence of both the parties were.
Essay number 238 of 23. Counsel for the parties are present. This appeal has been admitted by docket dated 21/2/2023. 21/7/2025 on following substantial question of law, the learned counsel for the parties have jointly submitted that eviction suit was filed on account of default and subletting, being eviction suit number 16 of 2011. Both the parties led evidence, and when the matter was at the stage of arguments, an order dated 3/1/20 was passed under section 15 of the BBC Act regarding payment of rent. However, the defendant defaulted to pay the rent, and consequently the defence was struck off by the order dated 11/2/20. The first substantial question of law is required to be considered in the light of the abusive facts as to whether the defence, having been struck off after adducing evidence, the entire evidence of the defendant is required to be ignored. Correct? What is the consequence of defense abuse?
Now, since the defendant has disputed the relationship of landlord and tenant, the plaintiff ought to have adduced his own evidence without taking aid of the weakness, I would say, weakness of the defense evidence. A brief background of the facts are required to be considered. Can I just place the facts from the trial court judgment? Starting from internal page 2. The plaintiff is landlord in respect of the house and premises situated in Ward 5, Old Ward 1, UK Statutory, wherein municipal holding number 99, situated over land under Khata 87, Plot 148, quarter number 4, having two shop rooms, district residence within jurisdiction of court, engineering shield, which is herein referred to as the tenanted premises. The defendant has been in occupation of the tenanted premises as a tenant under the plaintiff. It is further case of the plaintiff is that the tenanted premises is part and parcel of property known as desolate property, and plaintiff has been realizing rent from the defendant, and rent receipt used to be granted to him whenever rent was paid by him. It was further case of the plaintiff that the last paid rent by the defendant to the plaintiff in respect of the tenanted premises was 250 only per month, and the tenancy of the defendant in respect of the tenanted premises monthly tenancy, which runs from month to month according to English calendar. The rent for each month we can give on the last day of each month, and is payable by the defendant by the last day of the subsequent month for which rent becomes due. It is further case of the plaintiff that the defendant last paid rent for the month of September 2010 on 7th October 2010, and thereafter failed to pay rent in spite of repeated requests by the plaintiff and has become a defaulter. It is a further case of the plaintiff that the defendant is also subject the tenant premises to another person without knowledge and consent of the plaintiff. It is further case of the plaintiff that the plaintiff, whom his lawyer sent a notice to on defendant on 11/5/2011 under registered cover requesting the defendant to quit and deliver vacant possession of the scheduled property on or before expiry of 15 days from the date of receipt of notice, and pay entire areas of rent, else the plaintiff will be compelled to file suit for eviction of the defendant. It is a further case of on receipt of the aforesaid notice, the defendant sent a reply to his lawyer on 24th May 2011, whereby it was claimed in the earlier that the rent had been tendered by the defendant, but the same has been refused by the plaintiff, and therefore the same is regularly being sent money order. It was also denied by the defendant that he has sublet the tenanted premises. It is further case of the plaintiff that he has not received areas of rent described in Schedule 3 and the same is due recovered from the defendant. That before institution was sued, the plaintiff had issued notice to the defendant requesting to quit and vacate the sued property on before 15 days from the date of receipt of notice. The aforesaid notice was sent through lawyer.
for the plaintiff under registered post on 11/5/2011 and the same has been properly served on the defendant. For the case of the plaintiff, the cause of action for filing the present suit arose on 1st of January 2011 when the defendant failed to pay rent for month of October, November 2010 and subject the tenant premises in same continues month by month. Now the case of defendant. Sure, I'm reading from this, that the suit filed on date is not maintainable. Suit has been valid now. No suit under the heading of eviction suit is maintained as a defendant at the instance of plaintiff Lalit Kumar. There is no relationship of landlord and tenant between the parties, and as such, in view of such view of matter, under suit under section 11(1)(d) of the GRBC Act is entirely misconceived in the eye of law. The real motive of the plaintiff is to obtain a decree for right title interest in garb of eviction suit by circumventing law, by avoiding payment of court fee at adverse scale. Nature of speaking is irrelevant, but the main next from
Internal page 6.
internal page 5. About 7 lines from the top. The suit is bad non-joiner of the proprietor of firm namely Jaiswal Properties and non-joiner of Paket Lal Jaiswal.
Non-joiner is important?
No, because I claim that I was a tenant under this Paket Lal Jaiswal. The plaintiff is not the suit is bad for non-joiner of proprietor of firm namely Jaiswal Properties and for non-joiner of Paket Lal Jaiswal. Defendant has advanced distinctly that suit is bad for non-joiner of Paket Lal beside other non-joiner of Paket Lal has died leaving behind surviving legal heirs represented in his case. The legal representatives of Paket Lal are both necessary and proper party in the suit. The defendant is not the person holding the suit property described in Schedule A of the claim. The person in use and occupation of the premises in person in use, occupation, possession of the premises in person is Dr. S.P. Lal. Dr. S.P. Lal is alive and in possession of the premises in the suit. Suit is therefore bad having been filed against wrong person. Plaintiff cannot proceed with the suit in absence of Dr. S.P. Lal. The description given in Schedule A of the claim is denied, incorrect, incomplete. Defendant is not in occupation of entire holding 99. Holding 99 is a very big one. Plaintiff has not stated as to whose name under Khata number 87, plot number 148, town Chhatrapati stands recorded in service settlement. As far as defendant knows, the house and premises under Khata 87 is the property of Paket Lal Jaiswal, son of Kashina Jaiswal. Paket Lal Jaiswal has been executing registered deed of sale transferring the property under Khata 87. Even in 2011, Paket Lal has executed a registered deed of sale in respect of the property under Khata 87. Paket Lal is claiming the property on behalf of Uma Devi. There are only one room and veranda and not two rooms as stated. Plaintiff cannot maintain the suit unless the recorded rates of Khata 87 are made parties. And there basically the case set is that this plaintiff, who is Lalit Kumar Jaiswal, is not the landlord. The landlord was Paket Lal Jaiswal. He used to collect rent, issue rent receipts. And later on,
But the fact that you are a tenant is not in this.
I say there was on the Schedule A property, suit property is in occupation of one Dr. S.P. Lal.
That's right. But the fact that you are a tenant of, you are not claiming title.
I am not claiming title, but I say no. Further, your ladyship will find that there is a dispute with respect to ownership of the property between Paket Lal and Lalit.
That is the dispute that you have raised. But the status, your status is not that of a tenant.
Yes, I am not claiming title. I
You are
cannot
not
claim title. No.
You claim that you are a tenant, but you are a tenant under somebody else.
Yes, so I have. There is no relationship of landlord and tenant between
the two parties.
Yes. And there was also a difference that I had advanced a sum of ₹6,000 to Mr. Paket Lal and my landlord for his treatment, and he promised to adjust it towards future rents. That was also one of the difference taken.
But your defense has been struck off.
Yes, struck. Now the question is whether the learned court below could have really given a finding of relationship of landlord and tenant, relying upon the evidence of the defendant which has already been struck off. That is the question. Now, Your ladyship will find the issues which were framed. One, mainly whether there is a relationship of landlord and tenant who become parties. That is issue number 2, which has been dealt with. At internal page 22. But before coming to that, I will just take your ladyship to few portions of the evidence which has been reported of the plaintiff as well as the defendant.
First, we need to see the finding, no? How he has
Yes.
dealt with it.
Page 20.
This counterfoil of rent receipts was exhibited by whom?
The ladyship is referring to
Page number 13, internal page 13 of the trial court's judgment.
internal page 30.
On behalf of the defendants.
Yes, on
You
the
see, internal page 12.
12.
2 counterfoils of rent receipt has been exhibited on behalf of the plaintiff also. Right? These are exhibit rent receipt number 201 and 204. Are you the tenant?
Yes. Now these have been dealt with. Just
The exhibit which I exhibit 1 and 1. Lalit Kumar Jaiswal is the plaintiff.
was the plaintiff.
He has produced the rent receipts. What else is written?
There are just 2 rent receipts, exhibit
One is
and
sufficient.
1 by 1. The remaining which has been adduced by the defendant.
You forget about the defendant. The point is whether he has been able to prove the relationship of landlord and tenant.
But the ladyship will find from the findings at page.
First, you see, has these rent receipts been disbelieved?
Not disbelieved, but it was what I find from the
If
judge.
it has not been disbelieved by
It
the
was-
courts,
It was marked as exhibit with objection.
maybe. You see, that is not a substantial question of law. We are not bothered about it. Both the courts have believed those documents, right? Even if it was marked with objection. Those documents have been believed by both the courts, and these 2 documents are taken as dead. So this document was more than sufficient to hold that there was a relationship of landlord and tenant. So second question of law, even if you been on the first one, you know, stand.
First was essential. Second, even if plaintiff has to stand it on his own leg.
He is standing on his own legs because there is a clear cut exhibit 1 and 1, which has not been disbelieved.
The learned court below, apart from that exhibit has taken into account admission of the
No,
defendant.
you forget about that. You forget about the rest. Therefore, that is by second substantiation. We don't want a remand. We'll decide it here. So we have to see that. Whether the plaintiff, provided the first question is answered in it. So what do you have to say so far as first question is concerned? You say that it has been decided. On the last occasion when the substantial question of law was framed, you say that this issue is almost decided.
Yes, I was given 2-3 judgments.
What is the consequence? Has it been decided? Not decided. Has it
So
been
far,
decided?
it has been decided in one of the cases, admissions.
What is the consequence? It remains struck off from the date it is struck off, or it is struck off for all times?
That issue has not been decided, but the issue that what has come in evidence, that will be taken into consideration. That has been decided. Paragraph 18 of the
Paragraph 18. You providing a copy. Para 18. Yes, please. This is out of second appeal or first appeal?
this is out of second.
This was a substantial question of not being.
Sure.
This is not a substantial question.
That was not a substantial question of law.
Anyways,
But the issue,
you are referring to para number
18.
18. You read this.
However, the contention of the counsel for the appellant that court below should not have looked into or considered the amendments made in the written statement of the appellant defendant, since the defense was struck off in terms of section 15 and the trial court should not have passed the judgment and order on the basis of the evidence led by the plaintiff, though not disputed, but in my considered opinion, only the defense against ejectment is struck off and not the admissions made in the written statement. Section 17 of the Evidence Act 1872 defines admission which may be oral or written or by signs or silence or conduct, etc. And Section 18 enumerates the circumstances in which such admissions can be considered. It is well settled that admission in pleadings or judicial admission stands on a higher footing and is binding on the maker. Section 56 of the Evidence Act stipulates that no fact of which court will take judicial notice needs to be.
So these admissions are in the pleadings.
In the pleadings as well as in evidence both.
You see, the point
In the pleading is this.
Please appreciate this. The point is that when the defense is struck
That is
at a later stage, then under such circumstances, the entire defense is struck off. The entire, you see, take a situation.
Yes,
this is suit of 2011. Defense is struck off in 2010. You were supposed to make payment of rent. You were supposed to make payment of rent. From which date?
From date of order, section 15.
From date of order, right? When a person is supposed to make payment of rent in the date of order, it means that he has continued to pay the rent till 2020. Then should his entire defense be struck off or his evidence should be taken into consideration?
That is the first.
This is the isn't it?
Yes.
Then, if it has not been, this is not a directly an issue. This is not directly an issue.
Only the
And
admission
this is
on
not
the point
a
of
substantial question of law.
Yes.
On the point of admission, so far as landlord-tenant relationship is concerned, they denied the relationship in the written statement, as we find it in the records. So therefore, you see, the plaintiff has independently also apparently has proved the relationship by producing certain rent receipts. Rent production of rent receipt is more than sufficient. You don't need anything more. But this point is required to be considered.
Yes,
as whether the defense will go entirely or it will go only from that particular date. You were also referring to something.
I was referring to a judgment which on Patna High Court, and I have copied. But it is in relation to
This is again second appeal?
no,
Civil.
earlier it used to be.
Civil.
The relevant paragraphs which I had referred them was para 28, 34, 35, 42, 50, 51 and 53.
paragraph in particular do you want to make?
What is judgment lays down is basically what is struck off is defense as a tenant.
That's right. That is
Defense as a
well
tenant.
established.
Yes,
The
but
defense as
the
a
defense,
tenant.
that the plaintiff
There's
does
no
not.
relationship.
Yes, the plaintiff
That
does
is not
not.
struck off.
That is not struck off.
Yes.
And my second line of argument was that the plaintiff has to stand on his own leg. It has to establish the relationship.
No, no. You see, it's a very niche question of law. For that, no facts. Only whatever I have dictated is more than sufficient.
What your leadership has dictated today is that whether the defense which is already there before prior to passing of the section 15
but
order.
that also stands struck off. Is the point to be decided? I don't think that it can be struck off. It can't be so harsh. The eviction suit goes on for years together.
If your leadership gives me just one more day, tomorrow I won't be able to come because there's some personal difficulty. Day after tomorrow, I'll assist your leadership.
You also see this, it's very important,
Yes,
right? Because at later stages the defense has been struck off. The hearing has commenced.
I tried to find out, but I could not.
With the consent of the learned counsel for the parties, post this case day after tomorrow at 10:30. 10:30 बजे आ जाएगा. खोजिए इसको खोजिए. ठीक है? What is the consequence? It's a very important judgment. I don't think that this issue has been
I
decided.
tried to find out, but there was no such case.
And we have to keep the entire landlord-tenant relationship of the state into consideration. सब चीज ध्यान में रखना. ऐसे ना isolated case के लिए जीतने के लिए मत बैठो. फिर दूसरे में आप लैंडलॉर्ड बनेंगे, टेनेंट भी बनेंगे, so ensure that it is properly decided.